Mentioning?
My lord, mentioning upon notice, my lord, for inclusion in the list, my lord, and for defend number 7, my lord, mentioning, I sent the notice,
Next week.
plaintiff, my lord.
Any other mentioning? Origin side commercial division, adjourn motion, item number 1, Calcutta Commercial Bank Limited.
Oh,
My lord, in
Your
this
fault?
matter, my lord, I have filed an application for addition of party, and also, my lord,
You are plaintiff.
no, I am a party, my lord, seeking addition, my lord, third party.
Intervener.
I'm
I-
opposing this.
My lord, your lordship may consider me intervener. My lord, actually, there is no list pending. List is pending. My lord, I am saying that Calcutta Commercial Bank Limited, that is plaintiff, allegedly took some loan from my lord, Bikram Singh Nahar, my lord, took some loan from the Calcutta Commercial Bank and
My lord,
on mortgaging his property. Ultimately, he could not pay the debts of the bank.
You are creditor.
No, well, I want to, my lord, pay off the debts of the creditor and to the digital, that means the digital amount. My lord, kindly see, my lord,
All right. Yes.
the whole thing, I think, is being misunderstood by him. Pradeep Nahar, sorry, Vikram Nahar, he had mortgaged a property with Calcutta Commercial Bank. Calcutta Commercial Bank goes into liquidation. The property goes to the liquidator. Now there was a decree. The main part, the plaintiff is Calcutta Commercial.
You are
I'm coming to that. They got a decree against Bikram Singh Nahar in 1948. After that, what happened? Bikram Singh Nahar died. He had 2 sons. I'm the younger son. Elder son also dies. Who is the defendant in the suit? So as of today, there is no defendant. I have to be substituted. Now, your lordship, kindly see the last order which your lordship has passed. Your lordship has categorically passed an order to make an application for substitution and for me to bring in as a defendant. Unless that is done, nothing can be done.
No, I have not.
And the
finished my-
direction was on the liquidator.
because you are not a party as yet.
As yet, now his right, he claims, you are the agreement holder. What has happened in the meantime, my elder brother entered into an agreement with these persons. They
He
have
is the official liquidator.
official liquidator is a decree holder.
No, my lord, actually, official liquidator is not a
Official
degree holder.
liquidator last day, official liquidator learned counsel appearing for official liquidator
Confused, I say.
would like to file an application for substitution.
Yes,
He is supposed to be today here.
Yes, my lord,
exactly. He's not here.
application to be filed.
So
is-
that is to be
at
taken
all.
up first.
He
Let us
is not
fix
a
it,
party. I am still not a party.
Not a
because
party.
none of
I
you are
have to be
party.
made a party.
My lord, I'm before that.
I'm for the liquidator.
My lord, here, my lord.
All right, your application, I have heard your contention.
Yes, my lord.
Where is your application?
My lord, I filed it, my lord.
For the application?
GA2.
We have not been served with any copy.
Because they
They are not parties.
party. I've
No, no,
served them.
we are
They are
pledging.
trying to become a party because they say
that-
We have right to, my
no,
lord.
it's not. You filed a suit for
My,
specific purpose. In Deoghar.
Just a minute.
my lord will decide whether I am entitled to copy or not. My lord, I want to pay off the dates. Kindly see how many
That
things
is
are.
subsequent. Let that
Who
be
is
decided
he?
whether it be party or not, but
I am
the
property.
fate of this
Who
application.
is he?
I am
There will be some defendant first.
asking for your, I am paying, trying to
Just a minute.
relieve you from the date. I am trying to relieve you from the
I
date.
want to pay my debt. I don't
I
want
am
your
not,
support.
not
Let them
here
pay,
to hear your mutual fights.
Well, let my friend pay.
My lord,
That is between me and the liquidator.
first decide the addition of party. My lord.
Absolutely. Where is that application? Learned counsel for the official liquidator submitted that
My lord, it's a court liquidator, man.
হ্যাঁ, আমি পার্টি হলে আমি অপোজিশন চাই।
যেটা 90 কেটে দিন।
ও জানিয়ে দিয়েছে। ওনা উনি টাকাটা দিতে চান, দিন না, ভালো হতো। আমার টাকা লাগবে না,
Let you be the party
আমার
first.
টাকাটা লাগবে না, দিয়ে দিন।
Your client is very
Year
jealous.
number 2 is filed by the official liquidator,
No, my lord, court liquidator, my lord.
court liquidator, court liquidator. Praying for
Detective, huh?
দিন।
substitution as detailed in para 4 and 5 of the application. Full stop. The sole defendant expired on 6/2/48.
Abated, already abated.
Whether the question of abatement is there or not, that is to be decided. It is in the process of liquidation. Leaving behind him 2 sons, whom you want to substitute.
My lord, Vikram Singh Nahar, my lord.
বিক্রম সিং নাহা তো পার্টি রয়েছে এখন।
Oh, sorry, madam, it's Samar Singh Nahar.
সমন সিং।
No, no, Pradeep Singh Nahar, my lord, they are just confused, don't confuse it. It's Pradeep Singh Nahar. But I have attached the death certificate and they have produced the document, Pradeep Nahar. না না সমর সিং মারা যায়নি, বিক্রম সিং মারা গেছে।
বড় ছেলেও মারা গেছে,
হ্যাঁ।
এখন এটা হ্যাঁ,
এখন আমি না বিক্রম সিং কেন
মারা
করবো, মারা গেছে তো, কি দরকার,
সমন সিং মারা গেছে।
মারা গেছে তো।
হ্যাঁ,
হ্যাঁ,
শুধু
তো বিক্রম সিং নাহার পার্টি হবে,
বিক্রম সিং পার্টি হবে, পার্টি তো রয়েছে।
প্রদীপ সিং নাহার পার্টি।
আপনি টাকাটা দিতে চান বলে দিন, একটু বলে দিন আপনি টাকাটা দিয়ে দিতে চান, তাহলে আমার ওই ভদ্রলোক উনি বলছেন দিয়ে বলে দিন, তাহলে আমাদের আর দিতে হবে না।
সেটা আমার আর ওনার
না, আপনি বললেন তো টাকাটা আমি দিয়ে দেবো।
Problem is that you have stated Shamor Singh Nahar and Pradeep Nahar are 2 sons.
Yes, my lord.
You want to substitute Pradeep Nahar.
Because my lord, Samar Singh Nahar is no more.
Where is stated that?
is died.
That is not stated.
My lord,
That
as
should be
As
clarified.
such, I don't oppose because
The question of opposition, it is not a question of opposition, it's a question of pleading. Why the other son shall not be pleaded? That should be spelled out that he has also expired.
my lord, as because in their petition that is there, that's why I just missed it.
How can I,
My lord, kindly permit me to add one para in this.
I'll supplementary affidavit.
Yes, madam.
you can do it.
My lord, kindly give me leave so that I can.
My lord will give a leave, she can do
লাইনটা
it
কেটে
now.
পুরোটাই কেটে দিন।
It's just a formal.
এটাকে ফ্রেশ করে লিখুন, GA2 is 2 of যেটা বললাম ওটা ঠিক আছে, ওই অবধি থাক, filed by the office so and so, praying for this. এরপরে in terms of para 4 and 5, এরপরে বলুন learned counsel for the court liquidator today prays for leave to file supplementary affidavit.
Copy may be served upon.
Leave is granted. Supplementary affidavit is to be filed within 1 week. The matter will appear in the list on.
My lord, para 5, I have submitted that the petitioner states and submits that after the death of the defendant, the son of the defendant is required to be, no, my lord.
Yes, 2 sons are there.
Sons
Two
are there.
sons, one has died.
I kindly
is to
give
be
me
spelled
leave,
out.
I will,
Because the question will come up why both shall not be pleaded. Court should know that.
yes, madam. It's my fault.
The matter will appear in the list on 8th.
Got
8 is not,
some difficulty.
no difficulty.
My lord knows 7th is a holiday and there's a long weekend.
11, 12. 12,
Hey, Much obliged.
My lord, may I get a copy of the
no,
application?
not right now. We have no locus stand yet as yet.
My lord, unnecessarily matter is.
Let the matter be, some
lengthy,
procedural
drag.
corrections may be
My
done
lord,
first.
someone wants to pay off the debts, my lord, it is converted
outside
into
the
as if it's regular suit.
Settle it
Suit has
outside the
been
court.
disposed of, It is as if converted into a.
Absolutely not. I am concerned with the.
My lord,
For the bona fide.
somebody,
Now
not claiming
the
any right
letter
of
office will have
property here.
anything to say.
We are not claiming any right of property here.
He's an agreement holder.
Yes.
Can
My lord, I am not claiming any right over the
Go and
property
find
here.
in Devghar.
I want that really.
Both of you go and
mortgage
find
may
in
be reading.
Devghar, you will get
Only that.
traveling allowance.
Yes, my lord.
My lord, kindly see, we are not paying any relief against the property. We want to pay off the
Right,
debt.
with the substitution the made for.
Unnecessarily, it is converted into a suit.
Your client is very generous in paying
Yes.
my money. Thank you very much.
Settle it you outside the court. Next.
Regular list, new chamber applications, item number 1.
My lord, this is my application, my lord. I am paying for restoration of this application. The day of the dismissal of this application on 27th, my lord. So I am paying for restoration of the application, my lord.
I strongly oppose this application, man.
You are,
I am for the respondent. This is going on for,
did you appear anytime?
I appeared in before my Justice Krishna Rao in GA number 2.
Did you contest the matter?
Yes, my lord. It order
Why it is PLA?
this GA2 was disposed of.
No.
This PA, why it
No,
is
no, no.
PLA?
PLA, the matter is because it is reassigned to your lordship.
The matter should be, if you are contesting the matter,
No, my lord. It is a content, not is a. The order was passed, letter of administration, ex parte. We did not contest that. Thereafter, they made an application making many allegations and for appointment of special officer. Justice Muslim Bhattacharya appointed a special officer. They are not satisfied. Again, another special officer appointed by Justice Krishna Rao. Report both the special officers submitted the report. The GA2 also for appointment of special officer that was allowed and report has been filed and GA2 was disposed of in January 2023. Now, how this can be?
No.
Firstly,
My
dismiss-
learned friend is
Secondly-
totally misleading.
No, it's not misleading. I got the order.
The application will be came up for hearing then on that occasion. This is today the application kindly allow me to, this is my application, kindly allow me to make my submission first. My lord, this is a restoration application, my lord.
January 2023.
This is an application against the order dated 27th. My lord, the matter was dismissed, non-appearance on my part, my lord. So I have, the restoration may be allowed and the main application should be hard.
I will file.
And my
I
friend
will-
will get the opportunity.
submit please.
Yes. This is my application for restoration, my lord. On that day, my lord, when the matter was dismissed, my lord, I was not unable to appear before your lordship. And that's why I pray for restoration. Yes.
Now what you have to say?
Look, this-
Have you appeared in this case?
When PLA was heard, that time I did not appear. It was allowed ex parte. Letter of admission was granted. Now they filed an application before Justice Muslim Bhattacharya for appointment of special officer. That these things are not given to us. Special officer was appointed. Special officer filed report that was accepted. Again, they filed one application before Justice Krishna Rao for appointment of special officer. Another special officer was appointed. He filed his report that was accepted and that GA2 was allowed, was disposed of on 24 January 2023. As the special officer submitted report and as such GA2 2022 is disposed of.
In PLA 68 of 28.
68 of 2018. GA2 of 2022. Now, when
Order dated
24 January 2023.
24th January.
2023.
Where is this order?
It is in. It is in.
No, order sheet. Pick out order sheet.
Section of the report.
No.
Last line. Last line.
My lord, may I make my submission, my lord?
Let me see the order first.
Yes. And the contempt proceedings is also before Honorable Mr. Justice Krishna Rao. And they are facing that contempt also.
Then why this is appearing?
This matter, because they raised some serious question towards chair, my lord, and that's why my lord Justice Krishnara was released this matter.
No question
And
of
this
raising-
matter was assigned to this bench, my lord. There is a contempt proceedings is going on there.
When the matter was disposed of,
Why you are raising these points?
I will raise
Now,
this
my
point.
restoration
I will-
application, no, you have nothing to say.
Question of-
You are deferring the question, and that's why the contempt is lying
What
there.
was dismissed was the suit, not the
Yes.
GA. Suit was disposed of, dismissed for default.
Not suit, my lord.
that was mistake, I think.
GA
That was the
The GA2,
because there is no suit.
no suit, my lord. This application was on that day, my lord. 27 June 2020.
PLA 68 of 2018 should be restored then.
No, that was not passed.
No, my lord. GA
He is apply, he is
The
praying for
order was, whether mistakenly or not, suit was dismissed for default.
No, suit was not dismissed for default.
that
My
is
lord,
my
the
order.
GA application was,
That was my order. Suit is dismissed for default. So that restoration is to be made.
yes. I'm
That is to
praying
be
for restoration, my lord. Only I'm praying for restoration, and when the matter will come up before your honors,
My lord, if
I will make the entire
done.
submission
You're
before you.
interrupting every time when he's submitting. When your turn will come, you will submit.
ভুল লিখেছি ওখানে।
Yes, that is your prayer. GA2 with PLA 68 of 28 is restored.
Yes, my lord.
So 2 cannot be restored. Because 2 is disposed of. In terms of order dated 24 January, 2 is disposed of, 2 cannot be restored, technically speaking. This PLA can be restored.
My GA was not hard, my lord. That
It
is my submission.
disposed of. Whether it is hard or not, that is separate question. By order dated 24 January, it was disposed of. You have to challenge that order. Because I cannot restore this. This
Okay, my lord, we have an instruction, my lord, to file a application for exception of that order. I'm praying for restoration of the,
let the PLA number, PLA
Yes.
be first restored.
yes, my lord.
Because 2 has already been
Yes.
disposed of.
Yes, my lord.
The only remedy is you would have to go for appeal.
Yes.
GA 3 of 23 is filed. Praying for recalling of the order dated 27 June 23. It is submission, it is in the pleading that order dated 27/6/23 be recalled. And GA number 2 of 22 with PLA number 68 of 2018 be restored to the original file.
Yes.
The explanation is given for not taking any steps on the due date. It appears that GA number 2 of 22 was disposed of by a coordinate bench. Disposed of, coordinate likha darkar, disposed of in terms of order dated 24/1/23. Therefore, there is no scope in terms of this application to restore GA2 of 22. However, on perusal of the explanation and on being satisfied on the same, about the same, PLA 68 of 2018 is restored to the original file. Fixed 14th September for further order.
I'm grateful to your lordship.
This will appear in the list as adjourned motion.
Grateful, Your Honor.
ওটা adjourn motion হবে না, ওটা ইয়ে করে দাও। adjourn motion হবে না, রেস্টোর করে ওটা ফর হিয়ারিং করে দাও।
Grateful, Your Honor.
Item
Where is
number
your other side?
2 and 9.
Lord, kindly, Lord, close the argument in GS7. Because
GS7 is for?
for that strangers application, they wanted to be, Lord, heard pro into suo. I have made my submissions, Lord, Mr.
Mr. Dotto, you have
Roy.
submitted. That is not your application.
Because your lordship's desire was Mr. Ray, who was appearing
Anirban.
online on Irwan, my lord. He wanted to make submissions in GS7.
GS7 was actually, Lord, taken up by your lordship first. So, Lord, kindly close the argument in GS7. I have, Lord, in my submission, I have, Lord, cited, Lord, several judgments on that the pro inter suo does
Last
not
day
lie.
you made submission in respect of?
No, I was making submissions in respect of both GS6 and GS7. My submission, my lord, was
GS6 for?
GS6 is
GS6
my application.
by learned friends.
Your lordship has not heard that GA today. I mean, on the last occasion, actually, your lordship was hearing GS7. In a suit, Lord, for eviction, I have filed an application that, Lord, the lessee is not paying rent, despite, Lord, their
Direction for payment of rent.
direction for payment of rent, and, Lord, the other consequential reliefs. Lord, A to E has been granted in GS6.
Tax.
Yes, Lord, municipal tax and, Lord, some GST, Lord, payment, service tax payment. May I place, Lord, GS6? If your lordship permits, Lord, I can place, Lord, GS6.
Yes, do it.
Lord, so far as GS7 is, everything is done. Now, Lord, so far as GS7 is concerned, Lord, kindly, Lord, close the argument. So far
Yes, I
as,
have to hear it.
yes. GS7, Lord, may I place the GS7?
এটা সার্ভ হয়েছে এই সার্ভিস হয়েছে দাও সার্ভিস
Let me hear it in part, GS6 in part.
Very well. Lord, so
And I
far
will
as,
fix up for passing order.
yes, GS7, Lord, kindly close the argument because, Lord, they are prolonging, Lord, unnecessarily. These talks of settlement, Lord, are brought up, Lord, when the matter comes up, then, Lord, nothing happens. Now, Lord, so far as GS6 is concerned, Lord, may I just indicate, Lord,
So
this,
far as I can recapitulate,
yes,
there was a lease
yes,
along with construction of building and so on.
yes.
So that work was not fully done.
Yeah, may I just correct, Lord, this part of the fact. Lord, this is, Lord, 34 Jackson Lane. It's a property, Lord, which is containing an area of 1 biga 2 katas. It's a large chunk of property. Lord, this is a DT's property. Originally, Lord, official receiver was appointed in a suit, Lord, which was filed in 1948. Now, Lord, in that suit, officials receiver, Lord, sought permission to lease out the property. Then, Lord, official receiver was discharged, and, Lord, two Shebaites of this DT, they were appointed as receivers. And, Lord, this was done in 1958. Then, Lord, there was this lease was, Lord, coming to an end when, Lord, this Rajgarh Tea Company, which was the lessee then, that merged into Andrew by an amalgamation, order of amalgamation. Lord, an eviction suit was filed. Now, Lord, in the eviction suit, originally, Lord, an order was passed, which is at page 41. Kindly, Lord, come to page 41.
Dictated order.
Yes, Lord, this is, Lord, 22nd May 2003. On the left-hand side top, your lordships will find that this was said. May I just place it? In view of the discussion and terms of the negotiation between the parties, the matter is treated on the day's list and the following order is passed. It is directed that the defendant applicant, Andrew Yule and Company Limited, after demolition of the existing structure on the demised premises, being number 34 Indra Kumar Karnani Street, formerly Jackson Road, Lane shall start the new construction on the demise premises within 2 years from the date of this order and shall complete the construction on the said demise premises up to optimum height permissible for construction of a new building according to the plan sanctioned by the Kolkata Municipal Corporation within the extended time of 5 years from the date of this order, and the Xerox copy of the said sanction plan duly attested will be handed over by the defendant company to the plaintiffs. It is further directed that after demolition of the existing structure on the said demise premises, the debris that be removed by the lessee at their own cost. It is recorded that the value of the existing structure of the demise premises number 34 such and such, as determined by the approved valuer pursuant to the order of this court dated 16th April 1997, has been duly paid by the defendant company to the joint receivers pursuant to the order dated 16th March 1998. It is further directed that the defendant shall pay monthly occupation charges of rupees 1 lakh per English calendar month in place of the present rate of occupation charges of 33,000 per month from the month of April 2002 to 31st March 2008. It is further directed that the company shall pay the area occupation charges from the month of April 2002 to 31st March 2003 at the rate of 1 lakh per month, unless amount already paid within 8 weeks from the date of this order. It is further directed that the defendant company lessee shall pay to the plaintiff lessor monthly rent of rupees 3 lakhs per English calendar month with effect from 1st of April 2008, and there will be increment of 10% of the said monthly rent every 6 years until the expiry of the lease. To the extent of the increment in occupation charges, rent as ordered, clause 1, subclause 6 of the lease deed dated 4th February 1983 shall stand modified accordingly. Apart from the said payment of rates and taxes and other taxes preferred to in the said deed of lease referred to, it should be, lease, the lessee shall also pay all other taxes including water tax, fees or any other impost that may be levied in respect of the said demise premises by the Kolkata Municipal Corporation or any other authority from time to time. Certificate of the paid up rate bills from the Kolkata Municipal Corporation confirming that there is no outstanding dues on account of any tax in respect of the aforesaid premises shall be furnished by the defendant company to the joint receivers within a period of 8 weeks from the date hereof. Then the defendant company shall also furnish regularly and future the Xerox copies of the paid up rate of bills, etc. Then it is further directed that if the defendant applicant fails to start the construction, my lord may kindly mark this, on the demise premises within 2 years from the date of this order, then after 49 years, that is initial period of lease, there shall be no option by the lessee for renewal for further period of 19 years as contemplated in the original lease deed, and in this respect the operative part of the said lease deed containing the option clause shall stand modified. It is further directed that if the defendant applicant fails to comply with any part of the order herein before made, the defense of the defendant company shall be struck out and the suit which stands adjourned for 5 years from the date hereof will be transferred to the list of undefended suits for obtaining an ex parte decree. Now, my lord, the rest of it is not important. This is what happened. Now, my lord, there was a breach of this compliance with this order. Now, my lord, when there was a breach, we moved the court. And my lord, there was a compromise which was filed in court. Now, my lord, if your lordships kindly, my lord, come to page 46. Only the relevant clauses, my lord, I'll place. Page 47, if your lordship starts. Please take clause 3. It is further ordered that 5 years from
Just
the
a
date
minute,
of...
let me pick it up.
I'm sorry.
46, yes.
Page 46, it starts. Kindly come to page 47. This is the terms of settlement. Please take clause 3 first. It is further ordered that within 5 years from the date of the order, defendant applicant shall complete the construction of the building up to the optimum height in all respect ready for use and occupation, and submit a copy of the application made by the petitioner to Kolkata Municipal Corporation for issue of completion certificate, and shall forward the same within 15 days to the plaintiff together with an attested Xerox copy of the building plan as sanctioned by the municipal corporation. It is further ordered that the defendant applicant shall deposit within 8 weeks from the date of this order a sum of rupees 10 lakhs free of interest with the joint receivers as a security deposit for due completion of the construction of the building, which the joint receivers shall refund without interest to the defendant applicant upon production of the completion certificate. If the defendant applicant fails or make default in completion of the construction within a stipulated period in this order, then the sum of rupees 10 lakhs shall stand forfeited to the joint receivers. It is further ordered that the defendant applicant shall pay to the plaintiff additional premium of 10 lakhs within 8 weeks from the date of this order. It is further ordered that the defendant applicant shall pay monthly occupation charges at the rate of rupees 3.50 lakhs with effect from 1st April 2008 as per English calendar month in place of the present rate of 3 lakhs per month, and shall pay the arrear occupation charges from 1st April 2008 within 8 weeks from the date of this order. It is further ordered that the defendant applicant shall pay to the plaintiff monthly rent of rupees 4 lakhs from 1st April 2013, and thereafter monthly rent shall be increased by 12% every 5 years till the expiry of the lease instead of 10% every 6 years as per the order dated 22nd of May 2003. To the extent of the rate of rent and the percentage of increment period as stipulated in clause 1 subclause 6 of the lease deed dated 4th February 1983 and the order dated 22nd May 2003 made by the Honorable Justice Pinaki Chandra Ghosh shall stand modified. It is further ordered that if the defendant applicant failed to start construction on the defined premises within 2 years from the date of this order, then after 49 years initial period of the lease, there shall be no option by the applicant for renewal for a further period of 19 years with effect from 1st April 2029. 31st March 2029, the 49 years lease expires.
31st March.
2029. This renewal of
No renewal up for 19 years after 1st April 2029
absolutely.
in case of breach of any covenants.
And Lord, your Lordship has seen that in the earlier order that there was a provision that Lord, their defense will be struck off and the suit will be heard as an ex parte. Then Lord, please come to clause 10. This page 50, clause 10. This clause is repeated in page 10. Further ordered that if defendant applicant fails to comply with the orders herein before made defense, the defendant company in the suit shall be struck off and the suit which stands adjourned for 5 years from the date hereof will be transferred to the list of undefended suit for obtaining ex parte order. Then Lord, there are other clause. Clause 12 may be taken note of that Lord, the parties agreed that there will be a supplemental lease deed incorporating these clauses. Now, order, it was certified in the order, page 51, clause 16, that Lord, the order is passed for the benefit of the DT. Clause 16, last clause. Page 51, last clause, clause 16.
Yes. It is certified that the order is for benefit of DT.
Benefit of the DT. Now, Lord, what has happened is this. Lord, if your Lordships, Lord, kindly take Lord page 117. Which I just got. Up to November 2019, the rent was clear. That 12% increase now, Lord, has brought the rent to 5,28,000 and odd, and this has been further increased subsequently. So, Lord, as on the date of filing of this application, the dues was 1,58 lakhs, 59,000 and odd. Because, Lord, from December 2019, they stopped paying rent completely. Their property is being utilized, enjoyed by them without paying a copper. And Lord, so far as the DT is concerned, Lord, the entire income of the DT is out of this property. And Lord, therefore, Lord, today they are in a complete distressful condition. Now, Lord, supplemental deed was, Lord, also entered pursuant to this. And Lord, the supplemental deed, your Lordships will find from page 57. Page 57.
Supplemental deed of lease.
Yes, this was registered. And Lord, the clauses, the relevant clauses your Lordships will get. Lord, please come to page 63. Where, Lord, the order is quoted. All the clauses, Lord, in the settlement are quoted. Under second paragraph, your Lordships will find all the clauses are quoted. Then, Lord, please come to page 67, which says lessee's covenant. to pay the lesser.
Definitely, this is under, this is pursuant to the order.
Absolutely. Lord, in compliance with the order, the supplementary deed was executed. Now, Lord, all through the party, the lessor is the DT, and Lord, lessee is Andrew. And your lordships will find that in this lease agreement also, the obligation to pay the rent, the obligation to pay the corporation tax, and all other outgoings is on Andrew. Now, Lord, today, Andrew, after being served, has filed an affidavit. Your lordships may kindly have a look at that affidavit. This is an affidavit, Lord, which was affirmed on in August 2022. 8th of August 2022. This is an affidavit affirmed by Korno Mukherjee.
Yes.
Lord, I just Lord give a highlight because after all, Mr. Dotto is going to argue. Let him Lord take his points. But Lord, please come to page 4 of the affidavit, subparagraph 4. He says that there is no live cause of action. Lord, it is a continuous cause of action because the court has been giving them indulgence. It's not me. I had come up with a suit for eviction. The court has been giving them indulgence. Court is extending the time. And they are not complying with the order of court. And now, Lord, this is a dishonest stand, if I may say so, with greatest of respect. That, Lord, if they come and say that the suit is not a live suit, the suit for eviction remains. And Lord, the order of the court protects the DT, saying that if there is a default, then their defense will be struck out and the suit will be heard, Lord, as ex parte suit. This, Lord, protection the court has given all along when the court passed the order. Lord, the agreement, the DT, Lord, had agreed to this proposal of their construction and, Lord, enhancement of the rent only because of the benefit of the DT. That they will get a rent, Lord, of 5 lakhs and odd. It is 5,90,000 now.
When the tenancy was determined?
It has been, Lord, it was determined, Lord, when the suit was filed. Prior to the suit, prior to that. And Lord, this determination was, Lord, did not work out because, Lord, the court had intervened and passed an order. And each time the court recorded that this is for the benefit of the DT. It has not, from 2019 onwards, December 2019, it is not inuring to the benefit of the DT. And Lord, that is the protection provided in the order, saying that if it goes against the interest of the DT, then Lord, their defense will be struck off and the suit will be heard ex parte. That is the mechanism on which, Lord, court had extended the time. And Lord, your lordships may kindly seize the completion certificate issue and other issues, Lord, that he has raised. I'll leave it for him to argue. Lord, my short submission is that, Lord, today, this is my prayer. Your lordships may kindly take the notice of motion. Kindly see what my prayer is.
Notice of motion?
Okay, sorry. It must be, Lord, kindly see the prayer.
এটা কোনটা দিলে? 6
Up to E, Lord, is granted. Your lordship did not, Lord, bother yourself. Your lordships, I am not going to bother the lordship's court, Lord, with prayer A to E. Kindly see F.
From F onwards.
F.
Pressing for F onwards.
F onwards. And Lord, F is the completion certificate. This is clause 3 of the terms of settlement. Your lordship will get it at page 47 and 48. Prayer F.
Yes.
Then, Lord, the respondent be directed to remedy the breaches committed by the indenture of lease. Then by this payment of this 50 lakhs have now gone up. And Lord, area municipal tax, disclosing the names of the sublessees, paying outstanding lease rental charges from December to May 2020. And then, Lord, in the alternative, this is the alternative prayer. The failure of the defendant to remedy the breach within the time stipulated, we declare that the defense of the defendant has been struck off. The suit be directed to appear as an undefended. So, my lord, these are my prayers in this.
Next, I will hear you. I will pass order. এগুলো পাঠিয়ে দিলাম।
Reply.
My lord, I have served a supplementary affidavit. I've served upon them.
Ki supplementary
May I
affidavit?
fight? Yeah. আকৃতি list.
Okay,
দেখে না, দেখে না।
supplementary affidavit টা কোথায়? আছে?
Yes, my lord. My learned friend acknowledged that he has been served with a copy.
আছে।
And will grant me leave to file.
ওটা দিয়ে সবকিছু দিয়ে পাঠিয়ে দেবে।
Lord, so far as GA7 is concerned, Lord, kindly close the argument. Please close the
I will
argument.
pass order. Better I will pass order.
Because, Lord, otherwise this will go on. Lord, this third party has been created by Andrew just to, Lord, drag their feet.
I will pass order. Necessary order I will pass.
If that is the allegation, then I have to make one. There is no allegation on affidavit that I have brought in.
No,
the
no,
party.
I don't make this allegation.
Then
The
who is making
person
this
who has come, he himself says that he has got it from Andrew. I am not making any allegation.
That's a fact. And you have said so. Why is my learned friend feigning ignorance?
So
of that
therefore,
fact?
where is the question of any additional argument that I am making? I am just accepting the case that
All
they have
right, I
made,
will pass order.
and I have made my argument on that.
Next.
Item number 3.
Two and 9. Item number 9.
Lord, 2 and 9, they are, Lord, 9 is the, I think,
Six.
application.
Yes.
Nine
6
is our-
part heard.
Our application,
9 is part heard.
9 is part. And Lord, 7, Lord, please kindly dispose it of.
3.
Item number 3. Christopher Martin.
None appears. On previous occasion also none appeared. Let GA number 9 of 22 stands dismissed for default.
Item number 4. Ghonosam Bagri.
Lord, I'm the receiver, man.
My lord, in this matter, my lord, I am praying for not today, my lord. On behalf of my lord, defendant number 9, my lord, Mr. Rupa Ghosh is appearing. However, my lord, he is on legs, my lord, before court number 23.
Not today.
Item number 5.
Obliged, my lord.
Mukul Ghosh.
কি ম্যাটার আছে দেখি।
Item number 5. Mukul Ghosh.
আগের অর্ডার গুলো কি আছে? আগের অর্ডার কি আছে দেখি। Unappears. Adjourn to 8 September. 8 September না ওটাকে 14 September করে দিন।
Item number 6. Rajendra Kaur.
This is my application for defendant numbers 2A to 2H, my lord.
Plaintiff.
I am appearing with
For-
lordship before my learned friend starts. Lordship, I have received change from the erstwhile advocate. Since after that, I have appeared for on few occasions, but after that, the client is not in contact with me, your lordship. Would give me some time, your lordship, 10 days to revert back.
May I make my submission first? May I? My lord, I have made two applications, my lord, GA5 and GA6. This application, my lord, I have prayed for the applications to be listed as motion adjourned unopposed. Why I tell my lord will kindly come to page number 22 of this application. My lord, my application was for removal of a receiver. on the ground that the receiver had become a director of a company in which the plaintiff is also a director. There is conflict of interest which was never informed to us. So on that ground, we have sought for removal. Direction for affidavit was passed on 13th of July 2022, more than a year back. They did not file an affidavit. After 2 months, my lord, at page 23, my lord was pleased to again extend that order. They have not filed any affidavit in opposition. More
Let
than
the
a,
receiver appoint.
yes, my lord, for removal of that receiver.
Let the receiver appear first before.
My lord, receiver has appeared, my lord, kindly comes to page number 22. The receiver is represented, second
Today you
paragraph.
want to pass the order.
No, my lord, I am only humbly seeking that these applications be listed. My lord will see, I have mentioned this.
These are listed.
No, my lord, these were not listed, my lord. That's why I had taken out this
These
application.
two applications.
My lord, GA5 and GA6. The present application before my lord is GA7. Kindly comes to the prayer portion. My lord will see that I have prayed for, my lord, the listing of the two matters that my lord motion adjourned unopposed because they have not filed an affidavit for more than a year, my lord.
GA5 and GA6 only innocuous order that can be done.
Yes, my lord. Kindly fixes this.
Oppose your lordship, I was seeking.
All right, let those come appear in the list.
Definitely.
Then
your
make
lordship
submission.
would kindly give me at least 2 weeks
GA7
time.
of 23 shall appear in the list along with GA5 of
My lord, GA5 and GA6, my lord.
what GA5? GA5 of 22 and GA6 of 22 on 22nd September.
I'm grateful to my lord.
Oblige your lordship.
But this application can be disposed of. This application can be disposed of, my lord. That was
Lordship, I have no instruction. Lordship would kindly keep it all the applications together, your lordship, because I don't know what the instructions are.
my lord, on 22nd of September, if there is any instruction, submissions will be made.
Lordship, I don't know what allegations are there. Lordship would kindly keep it on.
GA7 stands disposed of.
Disposed of, my lord. Yes.
That is the only
Allegations are not admitted. If any allegations are there, Lordship would kindly
Senate
record.
counsel appearing for the ওখানে একটু লিখে নিন। Submitted that since no affidavit in opposition is filed, allegations contained therein, প্রথম থেকে লিখুন। GA7 is filed, প্রথম থেকে লিখুন। With a prayer for analogous hearing of GA5 of 22 and GA6 of 22 expeditiously. The learned counsel appearing for
Plaintiff, my lord.
plaintiff submitted that as yet he has no instruction from his client. Let these two prayers, let the prayer of analogous hearing of GA5 of 22 and GA6 of 22 be allowed without accepting or adjudicating upon the allegations made against the plaintiff in GA7 of 23 and without prejudice to the rights and interest of the plaintiff therein.
Obliged.
These GA5 of 22 and GA6 of 22 shall appear in the list on
24th.
22nd
22nd, my lord, I had directed.
22nd September.
I'm grateful to my lord.
Obliged, your lordship.
Would you like to file affidavit in opposition against GA5 or 6?
Lordship, I have already.
But without instruction, the first submission was I have not been able to get in touch.
I am
Directions if my clients
I am giving a direction. If
My
you
lord,
want to file-
my lord, directions have already been given. If my lord is extending the time after 1 year, my lord, I'll pray for costs, my lord. Because the suit of 1987, my lord. My application of 2022 is of, my lord, the direction was first.
Application after 25 years, so.
Yes, so that should not be a ground. 13th of July, the first order was passed.
Our count.
13th of July, the first order was passed, my lord. 2022.
Lord will kindly extend it peremptorily. If my clients do not avail of the long rope your lordship is giving us, then they will submit.
If they want to, let them file it.
affidavit in opposition is to be filed within 1 week against GA5 of
My lord, both 5 and 6, my
and
lord.
6 of 22. Full stop. In case of failure to file affidavit in opposition within the same period, which was initially granted
My lord, for
on 27th September 22.
Yes.
Right to file affidavit in opposition shall stand closed.
Lord, could it be 2 weeks? Well, there are two applications.
that submission should itself invite costs.
1 year it's pending for
I
1
know,
year.
but there are two applications.
No further 2 weeks.
কতদিন লাগবে? একদিন
Could it be till the 11th? Kindly gives one more week.
Two,
Could it
two
be till
weeks.
the
2 weeks করবে।
I'll file the reply within the.
Case affidavit in opposition is filed. Affidavit in reply is to be filed within the returnable date.
I'm grateful to my. No, no one has. No, receiver didn't pray for extension also.
No extension because I have closed it.
Lordship would kindly.
I'm extremely grateful to my.
I'll convey the order, your lordship. I'll pray for
That's
my
up to the
retirement.
client.
If the client is not interested, I'll pray for my retirement. There's nothing.
So your doors are closed.
Obviously.
Grateful to my.
Oblige your lordship.
Mr. Sen, you are in 7.
Item
Item
number
number
7.
7.
Well, this is a very innocuous prayer, my lord. Kindly see the suit is of 1989.
I'm appealing for the plaintiff.
It has been decreed. There are 2 exhibits which were produced by my client by way of evidence, and they were called to give evidence by a subpoena. I am not parties to the suit. So those documents which are lying there are documents of title deed. So my lord, this needs to be returned back to my client because the suit is decreed. And now, my lord, kindly see these documents once. My lord, list of exhibit, your lordship will find this. Before that, I'll show your lordship the subpoena, which calls for production of those documents, page 78.
Call for a report from the registrar original site. Because recorder are not placed today.
But I don't know whether all the parties have been served, my lord. I am for the plaintiffs.
I cannot serve everyone, my lord. I am not a party.
Right.
Court called me. Just, your lordship will only see the subpoena once, your lordship will see.
Registrar original site shall submit a report along with necessary part of the record on prayer A and B in accordance with prayer A and B.
Very well.
Before the returnable date. Let the matter appear in the list on. Anyone like to file affidavit on?
But I need not to file it.
Appear in the list on.
But I don't know whether all parties have been served.
Does not matter. I am asking from the court record.
Why did you serve me?
13 September.
Oblige, your lordship.
Item number 8. Sitaram Education Center Private Limited.
It's my application, my lord.
You are?
My lord, I am the plaintiff.
Who is defendant?
My lord, service. Huh? Service for it. We have served, my lord. It's a application for restoration. Suit was dismissed for default, my lord.
Order sheets? Application?
Lordship's order of dismissal is at page 20,
You
19th
are
of
appearing
January.
for plaintiff.
I am appearing, my lord, for the plaintiff.
Sitaram Education Center.
Lordship,
When it was dismissed.
my lord, 19th of January, 2023. And my lord, I've given the cause list of the day at page 38. My lord, there seems to be a typographical error or my lord, an error in printing, because if your lordship takes page 38, item number or serial number 84 is
Have you served it on defendants?
Yes, my lord, that's my
Where
instruction.
is the affidavit of service?
Affidavit of service. It's filed, my lord, in your lordship's brief. Receive করেছো তো? It says what? What is the endorsement? So it's not good.
GA 10 of 23 is filed. Praying for restoration. Suit was dismissed.
Yes, my lord, the suit was dismissed. Page 20, lordship's order of 19 January 2023.
Restoration of the order dated 19 January 2023. Dismissing the suit for default. Along with pending applications. Affidavit of service is filed today.
So I have to
Full
say
stop.
it.
Let the same be kept in record. Delay is explained satisfactorily. Reasons for not taking steps are accepted. Let prayer A, B, C. I think there was no interim order.
Yes, my lord. There was a subsisting interim order which, my lord, I'm seeking, my lord, be restored as well.
Which was?
My lord, that interim order I have annexed, lordship will find at page 25, annexure C. অদ্ভুত টাইপের লোক।
Page?
Lord, 21 and 25, lordship will see at 21 there was appointment of a receiver, and 25, my lord, further interim orders.
Interim orders. Subsisting interim orders. ABC. D are allowed. That this should be restored in the original file and shall appear in the list on. What is the stage of the suit?
My lord, some of the defendants have still not filed their written statement, but we have to, my lord,
Alright. Let the suit appear in the list on 26th September. Post up. The register original site shall submit a report on date of service of summons on the defendants, date of appearance, and date of filing written statement, if any, before the returnable date, on or before the returnable date.
I'm extremely grateful, my lord.
Let that be decided. If it is not filed, then it will be undefended.
No, 3 have filed, 2 have not, or 4 have filed,
Let
2 have.
let that be
Yes, yes, my
incorporated.
lord,
into the-
yes, yes. And, my
Judge's
lord,
brief.
no, not yet. My lord, the inspection discovery has not yet been completed since the written statements have not yet been, 2 are yet to file.
That must be. it should be
Lordship can
ascertained.
issue those directions. May I also seek one indulgence from your lordship, my lord, the receiver to act on a sign, server copy.
Come on the next date.
No, the order that you have passed now,
A copy of this order may be sent to the learned receiver.
Judge, I'm grateful, my lord.
The application disposed of.
Lordship has disposed of the application. I'm grateful.
Disposed. Item number 10, 15 and 16.
10, 15 and 16, my lord. I am for the 10 and 16. I am for the petitioner, my lord. There was an order passed on 4th of August.
Other side.
My lord, I am appearing for the trustees, for the 3 trustees. And by the order dated of 30th August, my lord has fixed the matters on 11th September. My lord, I am
There
placing
was
the
a-
last order. my lord.
Just a clar- My lord, initially there was an order passed by my lord in GA7, 4th August, and my lord was pleased to fix the matter on 1st of September. In the meantime, on 30th of August 2023, the matter came up before my lord, and my lord was pleased to fix the matter on 11th of
GA
September.
5, 6 and 8 shall be taken up on 1st September. That is the order.
That was the initial order, 4th
That was
August.
the initial order. My lord, I am
And
placing the
thereafter,
last order.
the matter came up on 30th August before my lord, and my lord was pleased to fix on 11th of August, 11th of September. And
Okay. So all this matter will appear on 11th September.
And in the meantime, there was an order
My lord.
passed. We have not received the report of the special officer, my lord, appointed by my lord, in terms of the order dated 4th August 2020.
Come on that date. I'm not passing any order. In terms of order dated 30th August 23. 30th August 23. GA 5 of 22. GA 6 of 22. And GA 8 of 23 shall appear in the list on 11th September.
In terms, and the report may be handed over on that
Report,
day.
which report?
The report in GA7, there, my lord was pleased to appoint an assistant registrar.
How can I pass an order in GA7 that is not listed today? Come on
The
that
GA7 has been disposed of, my lord. This is the order. GA7 has been disposed of, and there was a.
Come on that date, I will pass order.
Grateful, my lord.
I'm not supposed to pass any order today.
Item number 11,
11, my lord, is my application. Your lordship recalls, my lord, that, my lord, this matter was appearing before your lordship, my lord, 2 days ago. And I had expressed my difficulty, my lord, that the wakalatnama I sought to file.
Yes, I have passed your order, give a leave.
Yes, my lord. Now, my lord, the application for substitution is affirmed, my lord. If the leave is granted, my lord, I shall, my lord, file the application. The difficulty is, my lord, defendant number 2 and 6 have passed away, which I have been informed by letters by my learned friend. My lord, I have annexed those. The application is affirmed, my lord. If your lordship has granted me leave, I shall file the application. Let them be substituted. And my lord, this application can be taken up.
My lord, this has been going on for quite a while, my lord. This is we've served them in February. Lord, there has to be some
Yes.
the
They
intimation
are
has to
filing
be
the
there.
application today.
I'll, my lord, give my objection to that. If they
Let
file
that
it,
be
my lord,
filed first.
yes, then I will.
Granted to file. Leave granted, করে দিন।
Leave, my lord. It's not, lordship is not condoning the delay, my lord.
No, it is not
Yes.
condoning delay. Leave to be granted to file, then I will hear.
Yes. Then I will, my lord, give my objection.
This much.
Then you will file affidavit in opposition if you think.
Yes,
all these things will be
of
done.
course.
Exchange of
My
affidavit.
lord, I don't know
And
why.
if you think affidavit in opposition or exchange are not necessary, I will pass.
No, my lord. Only thing, my lord, why leave is
Come in
required.
the list first.
See, the reason is,
Let it come in the list and filed.
Okay, leave required.
It is not numbered yet.
No, it's not. The only thing my lord, why leave is required to file the opposition, my lord? Why?
no,
that's
I'll tell you,
that
my lord, the
needs to be-
There are some
difficulty
problem with
is,
wakalatnama. That's why.
No, Wakalatnama is fine, but why the
Then you
application
file
needs
it.
to be filed?
Then you
Yes.
file it in the department. What is the problem?
my lord, the wakalatnama, my lord, the ledger does not contain, my lord, the name of the erstwhile advocate. The, my lord, initially the
That
brief
leave
was,
granted.
that leave was, my lord.
Yes.
My lord,
Right,
the wakalatnama I understand is lying with your lordship's officers, my lord.
Yes.
On
Okay,
29th, my lord.
Anyway, you file it if the notice.
My lord, if the leave is granted for
Lord.
file the wakalatnama, that should be sufficient.
Yes. Yes.
Objection আছে, হাতে থেকে বোঝা যাচ্ছে না। No objection আছে নিয়ে নাও। যারা করতে করবে আসবে করবে।
But if leave is granted to file my wakalatnama, that
Wakalatnama,
should be
my lord, not the
sufficient.
application.
And my lord, I will take necessary
Yes.
steps in course of the day.
Leave granted.
হ্যাঁ,
File
বলে
wakalatnama. ওটা তো এমনি leave হয়ে যাবে।
That leave is already given, your
Ah,
lordship.
that's
Yes.
all.
Nothing else is
File the
required.
application then.
Yes.
File the application.
File the application.
And
today
I'll
itself.
contest it, my lord, as and when it appears before your
It's
lordship.
appear in the list, you contest, you make
Absolutely.
your submission, whatever you like.
Absolutely.
Yes, my
I'm
lord.
grateful.
Today itself, I shall submit for master summons taking out. That will be done in course of the
Yes.
day, my. Deeply obliged, my.
Copy please off to us. हाँ, copy तो देवे।
अभी master summons कैसे?
अरे उसके एडवांस कॉपी दे दो ना, क्या है?
वो leave तो wakalatnama तो administrative में तो order है কিছু। हाँ? Application file करो। The matter will appear in the list. Not this week করে রাখো না।
Yes.
It will be not this week.
Not this week, no, 2 weeks time. কেন ওরা তো আরে
Let it appear in the next week.
Yes, my lord.
যেদিন return.
My lord, as I understand, the
Return of
rules
the
provide, my
recipe.
lord, 4 clear days for the master of summons. That being done, my lord, I shall serve with
All
the
right,
master
not this
summons.
week.
Not this week, my lord.
Follow the procedure.
For hearing, item number 12,
My lord, this is the
Yes, I can
judgment of an
remember this.
application. My lord, we have completed our submissions. My lord, the
Please, very
written
to
notes.
outside, right, Mr. Bosch?
Lord, Mr. Bose, my lord, is not available today, my lord. I'm appearing for the defendant, respondent in GA 11, my lord. And we had opposed the
Have you
GA.
anything to say?
My
Yeah,
lord, they have filed
My
their
lord,
written notes.
my lord,
They have given us.
we have,
argument are
my
given.
lord, we have filed our notes of argument, my lord, short notes of argument, my lord. Our short,
That's all.
my lord, our short point is only that, my lord, there is no admission in the
Yes, I
affidavit.
remember.
And my lord,
that.
even if there is,
Rather, it is admission, according to you, it is rather admission of the plaintiff
Of the
witness that it was rupees 10 in the year 2003.
absolutely, my
So
lord,
it will
obliged.
be rupees 5, supposed to be rupees 5.
Obliged,
That is your
obliged.
point.
Yes, yes.
All right.
And my lord, even, my lord, our judgments are there, my lord, which say that the court is not helpless to reject, my lord, an application on.
Have you
judgment.
annexed that those judgments?
My lord, we have.
I've reserved it for order.
My lord, notes, my lord, after the argument, my lord, may I
My
just
lord,
file?
we have not received a copy for them.
You will give a copy to my lord.
Reserved for order.
Obliged,
Argument concluded, reserved for order.
obliged.
I have 2 orders to write today, so it will take a little bit time.
My lord, your lordships have, my lord, indicated any date for the
Let
rest
me
of.
prepare it. I have 2 things in my hand
Well, your lordship will give it at your lordship's convenience. My lord,
because
My lord, for the-
fortunately I have no criminal matter right now.
well, we,
Deeply obliged, my lord.
It will not be for 1 year. It will be not pending for 1 year.
Only one thing, my lord. Even apart from, my lord, notwithstanding GA11, whichever way your lordship decides, my lord, the other, my lord, GAs, which is, my lord, the special referee's report and, my lord, the challenge to the special referee's report on which we are seeking a decree, 9 and 10, GA 9 and 10.
These judgment.
This will not, my lord, affect that.
No, this will come. I was thinking that day, it will come. You have to face it in another case. Mean profit. I was hearing mean profit, you were other side.
Oh, previous. Yes. But, my lord, this, my lord, is independent of that because, my lord, here.
No, that judgment is a ratio resident is very important.
I see.
So there are realities, ratio resident, very important.
I see.
Because what happened in this case, that is to be kept in mind. If someone realizes it on future, Supreme Court passed the order that mean profit is to be paid from the date of termination. Why? Because you have claimed that. That is the difference. In some cases, Supreme Court said, if you have not claimed that for this period, that is pre-institution suit period, then possibly mean profit cannot be given.
Your lordship is absolutely right. But in our case, the Supreme Court
No,
has
I'm not
fixed the
going
period.
to your case. My point is that case, if relied on in some other cases, that should be the distinguishing mark.
Yes, right. I completely agree with you.
One is a claim, there is claim, another is there is no claim. If nothing is claimed, then possibly this judgment will not help. You raised a claim, that is mean profit from the date of termination.
Yes.
Till pre-institution.
Right.
This can be claimed in the plaint.
Yes.
If this is not claimed, then what will happen? What will be the effect when the mean profit will be calculated? If this claim is not made, then at the time of calculating mean profit, this will not come.
I appreciate. My lord, let me argue it. My lord, your lordship has kept that matter for further arguments.
No, not in this matter.
No, in that matter.
Possibly, if there is raised.
No, your lordship is right. My lord, this is a contentious, my lord, point.
Depends on pleading.
Yes, yes.
As of right, you cannot claim.
My lord, that is absolutely right, my lord. I think we will have to, my lord, address your lordship on that. But yes, it is, my lord.
Not in that case. In general proposition of law, I am speaking of.
Well, a general proposition of law, the question is, my lord, one of limitation. Number one. Number two, the one of, my lord, the claim. Now, my lord, the question is, when does the occupation become illegal? My lord, that is, my lord, the question.
From the date of termination, next date from the date of termination.
My lord, that is one, my lord, view. The other view is, my lord, from the date of decree.
So far as claim of mean profit is concerned, we have 3 periods.
Yes.
One is pre-institution.
Right.
Another is pendency. The third is after decree.
Right.
That is up to 3 years.
Right.
From the date of decree up to 3 years. That cannot be extended beyond that.
Right.
Now, so far as that is, I have seen number of Supreme Court judgments. When you are instituting the suit, cause of action, one of the cause of action is for the period between institution of suit and date this
illegal
occupation become illegal or unauthorized. You have to incorporate in pleading.
Right.
If you know to incorporate in pleading, then what will be the effect?
Well, the effect is, my lord, there is no claim in the plaint.
No claim in the plaint. In that case, while calculating mean profit, this period cannot be taken into consideration. Is it so?
Well, I will have one more look at it, my lord. Let me, my lord, try to, my lord, actually.
Because I have seen number of judgments. If you do not claim it, mean profit is a separate cause of action.
Yes.
So if you have not incorporated into it, you have abandoned it. That means tantamount abandoning the claim.
Right.
So subsequently, court cannot revive this.
Well, in that case, my lord, perhaps the order to rule 2 principles will also step in.
Order to rule 2 in a separate suit, maybe. But in the same suit, when after passing the decree under order 20 rule 10, court can look into an inquiry into mean profit.
Yes.
In that matter, in the same suit, whether that can be included.
Let me look into it, my lord. Let me not, my lord, speak off the cuff.
A couple of judgments are there, I've seen.
No, my lord, I think, my lord, let me look into it, my lord. What your lordship is asking, my lord, I have, my lord,
I'm
some
not thinking
idea.
about this case or that case.
No, I understand, my lord. Let me also, my lord, study this because I don't want to, my lord, make an irresponsible statement before lordship. Let me, my lord.
In this case, my lord,
no, this is not
a different peculiar situation is there, my lord.
It is a separate case.
Yes.
This is not the issue.
But here the plaintiff had crystallized the amount.
Because someone may come and say, rely on Sudera reality. That is the distinguishing mark.
Yes.
No, I understand. My only one small submission, my lord, so far as this GA 11 is concerned, it has, my lord, no nexus with GA, my lord, 9 and 10. Because that, my lord, is independently your lordship, my lord, this is on an admission. But my lord, independently, we have sought a decree on the special referee's report, and my lord, none have taken an exception to
That is for the totality of mean profit.
Right.
Yes.
Now here we are claiming for part payment.
Yes.
This much.
And my lord, your lordship had, my lord, earlier.
Because I have not heard as yet on the totality of
No,
mean
no, no,
profit.
your lordship has not.
I have heard only whether on admission things should be returned to you or given or refunded or deposited, whatever that might be. This much.
And my lord, your lordship had earlier, my lord, by way of an interim order, directed them to, my lord, make a deposit, which was made.
Yes.
My lord, in case your lordship, my lord, finds favor with the application, in case, my lord, in that case, my lord,
Adjustment
payment
is
should
to
be
be made.
directed. Payment, yes.
Adjustments are to be made then on the order.
And my lord, then payment, my lord. Okay.
Yes.
Grateful.
Grateful, my lord.
Item number 13, said Juala Prasad Bhartiya Charitable Trust.
May it please your lordship, my lord. My lord, I appear on behalf of plaintiff. My learned friend, Mr. Dotto, is for the defendant. My lord, on the last occasion, my lord, we had completed our submission and Mr. Dotto is to give the reply today. It was your lordship's pleasure that we hand over to your lordship a written notes of argument. My lord, may I just hand it over to your lordship? And a copy I'm giving to my learned friend.
Have you given the copy?
Yes, my lord, I've given.
All right. Now your point is whether this suit is maintainable or not.
Yes, my lord. Basically, we had said that at the point of time when the application was made, which was made nearly 5.5 years after the passing of the order for transfer of the suit from original side to the ordinary suit, my lord, they've made this application. At that point of time, the originating summons suit was not in existence because admittedly, it was already transferred to that of an ordinary suit. And my lord, after the originating summons were transferred to the ordinary suit, that OS number got changed and CS number had come as per the original side rules. Thereafter, my lord, many an order has been passed in the presence of both the parties. And they had, my lord, sought direction in that ordinary suit on many occasions. And the last direction that was given was the matter was to be made, the suit was made returnable for the purpose of framing of the issues. And it was just a day before the suit was made returnable that this application has been made. So, my lord, we have also taken the point of estoppel. We have also taken the point of, my lord, and my lord, one point that my learned friend had taken was that the honorable court, the honorable judge at that point of time, having made that order for transfer, did not have the determination. As a result, the order is void. My lord, our submission to that has been that determination is an administrative procedure that, my lord, is done by the Honorable Chief Justice of any court, as a result of which that cannot take away the jurisdiction. That was, these are the main points.
May I please? My lord, the first submission, if I could understand the sum and substance of my learned friend's submission was, even if there has been a deviation of the process, that has been waived by the conduct of my clients. Now, my lord, your lordship knows, and I need not repeat or cite authorities for this proposition, that waiver means giving up of a known right. So the argument itself has inbuilt a defense, which I am trying to say that he acknowledges that I had a right. In this case, the right would mean that to come before the court and say that, look, the process of originating summons have exhausted itself. If it is to be treated as a suit, kindly ask the parties to go and file a separate suit before the appropriate forum and let the suit proceed in that manner. I had that right and I have given it up by my subsequent conduct. What is my subsequent conduct? My subsequent conduct is I have participated in that proceedings thereafter, and certain orders have been passed from time to time, which orders, my lord, would tantamount to evidence of the fact of waiver.
No,
Now, my lord, I say,
one thing is that if a probate application become contentious, someone files a caveat. There is a provision in original site rule to convert it to a contentious cause. Whether there is any provision in
that isn't it. It cannot be because, my lord, if your lordship sees the petition for probate, your lordship petition for originating summons, your lordship will see that the form is in the nature of questions. And the opinion of the court is sought regarding interpretation of a document. And the chapter goes on to further say that in the event the court feels that evidence of such nature which is necessary can be taken on affidavit, court can invite it. But if the court feels that this is a question which is contentious and needs to go for trial, or other questions of law are involved which may not form or cannot be passed in the form of an opinion of the court, they are issues inter se parties, my lord, then it has to be go by of a suit. Because, my lord, thing is that under the originating summons, the process under the originating summons is, my lord, there because there are issues. Suppose, my lord, a trustee cannot understand. If your lordship sees the list, your lordship, suppose a trustee cannot understand.
five issues are there.
Yes. Trustee cannot understand
Matter in probate matter, administration suit.
or interpretation of a will. Then, my lord, an executor can come before your lordship and say that, look, I'm the executor. I'm unable to understand you. The court give me a clarification or give me an opinion as to how I should act. But here is a case where, my lord, the issues which I have raised and I have pointed out are all inter se parties and they are trustees who are fighting amongst themselves. And there are allegations and counter allegations. There are allegations of defalcation of funds. And, my lord, there is a question of limitation involved in there. And I showed that all, my lord, on the day when I placed my application, and I shall just briefly refer to it. So far as my learned friend's defense is concerned, my lord, I say that so far as his contention regarding waiver is, he admits the fact that I had a right. The question is whether by participating or, my lord, subsequent orders being passed, whether I have waived that right. Now, my lord, the authorities which my learned friend have cited, they themselves go to show that all things cannot be waived. There are certain rights which can be waived, which are personal in nature, which the benefit I am getting.
There is no waiver against statute.
Yes. And, my lord, these authorities, if I may show, my lord, show, in all these, the question of waiver has been discussed, but in two of the judgments, I can very clearly show the court has rejected the argument of waiver. The first judgment, which my learned friend has cited, is 2004, volume 8, Supreme Court cases, page 2.
Have you given these judgments?
Yes, my lord, my learned friend has cited authorities.
My lord, they're all here.
You annexed with it.
Oh, copy nahi.
I think I had handed over the judgments.
Chalo de diyeche.
At least sign.
Oh, it's not signed.
At least sign at least one page. ওইগুলোকে আছে কি ওগুলো রেকর্ডে? No, we filed a compilation that was returned.
Yeah, my lord, that is what I had told my advocate on record. I don't find it. That's the only problem.
You do one thing, you take it back,
Yes,
give it signed, annex with all the
I will
notes
do
of and file on the next date.
I will do that. That I'll do. My learned friend can continue or
So without,
without this.
copy, I need a copy of the judgment. I was under the
It will take
impression.
1 or 2 days.
Your lordship will kindly keep it sometimes next week. Anytime next week, it's all ready.
Except
It's
8th.
Except
8th.
Anyway, except 8th.
8th.
Except 8th. That's what my learned friend is going to take care of
Where
the
will you
holiday.
go? Where will you go in rainy season?
We look Purulia.
I have visited Jalpaiguri, nothing to be seen. Forests are closed. It is so much rain. We cannot go outside.
No, Willard, what I enjoy is the drive.
That's true. But if the road is good,
I believe, Willard, I'm told by my colleagues that the
I
road
could not
is.
drive in North Bengal.
Yeah.
Chances of
Bengal roads are-
landslide was there.
And during the monsoons, it's also risky to drive that side. Your lordship will keep it any day, my lord. Then I apologize for the inconvenience. It could have been over today, but I'll get it done.
6th.
6th or তুমি
Yes,
তারপরে
yes, yes.
চাইছো? Your lordship, kindly keep it after the 7th or 8th.
I have
my
no
lord.
problem with 6th.
Any day after the
11,
7th.
12, 13. Because I want to finish it.
Yes, yes, my lord.
Yes,
We
yes,
would
yes,
also like to do it. We would also like to do it.
11th.
Deeply obliged. 11th.
13th part adjourned to 11th. Did not you say anything at the time when that order was passed?
I beg you, I was not there. I was not
No,
there.
but
The
the
moment
defendants
I-
are represented.
But the moment I got an opportunity to read the papers, I thought that this was not the process. This could not have been the process. And your lordship will just, my learned friend's argument was, and I have pointed it out to your lordship, is that this proceedings can be converted into a suit. Now, your lordship will just, I was also trying to think, if this is converted into a suit, your lordship will have to pass a decree.
No, the very form of the plaint will be changed.
Right. But that apart, would your lordship, if I may ask myself this question, able to pass a decree on a petition where there is no prayer for passing a decree under any of the known provisions of law? In a suit, your lordship will express your lordship's opinion as to what?
No comments.
My lord, my lord, if I may just, as my learned friend has.
Come on the
point-
next day because
Yes, I will.
let me see the judgment.
I will come. We have also dealt with this point with regard to reliefs. They can be molded.
How much can be molded? There is no
Yes.
express provision of
The
law.
opinion. Molded means you have a relief and you are entitled to a larger relief. The court can see if it comes within your cause of action, court will do it. That's the relief.
My lord, any
Or can
question,
reduce.
any
an
opinion
or
which is
relief.
made into your, my lord, a question form.
I have
With
faced number
respect-
of orders like this. Order of mean profit, calculation of mean profit before passing the decree.
Your lordship was just
No, not
expressing.
this one, another one.
No, we also got, my lord, judgments on that. I'll
But
get the
profits
judgment.
can be waived.
I'll get the judgment.
Mean profits can be waived.
14.
Item 14, VK Udyog Limited.
My lord, I appear for the plaintiff, my lord. On the last occasion, your lordship had directed for inspection of documents of the defendant number 2. We had gone to the office of the advocate and record, but my lord, none of the documents were allowed to give an inspection. Now, the reason was.
Your lordship, possibly it's a wrong submission, your lordship.
My lord,
If I may say,
letters.
if I may say, your lordship, there was a letter issued by them that please come to the court for the inspection of the records. Now, possibly there was a misunderstanding or a misinterpretation. They meant to bring all the documents, that we should bring all the documents over here in court, but that is not possible. They should ask for an inspection to be offered. We will give them an travel time so that they come to the office.
Giving you time, if it is not done, I'll pass order necessary.
Lordship, now in
Go
that.
to his chamber and inspect the document.
They have not
went,
come.
man. I have went.
It's-
My lord, but my lord,
You
inspection.
fix the date. Look, don't what.
They have not
meddle
come,
with
your
each other. Fix a particular date, fix a
That we
particular
will
time.
give your
Let
lordship.
go there.
Already,
Your
my lord,
lordship,
but my lord,
if
the
I may.
reason given by them was that during they.
Mess with it. None of you should mess with it.
No, your
Fix a
lordship,
date.
I'll tell your lordship what's happening. That misunderstanding was there,
Which
and
date will you go?
your lordship, before lordship directs any date, your lordship, we have already written to the Bangladesh bank, because our client is the Bangladesh LC issuing bank, to send all the papers, your
This is
lordship.
another LC issue. Another LC case.
This is also an LC case, your lordship. It's a Bangladesh bank, your lordship. We have already written to them to send all the original papers, your lordship. It will take some time.
Right.
And
The reason given by them,
offer an
the
inspection
letter
of later.
was they are
Learned
saying
counsel
that
for the, all right, come next date. Learned counsel for the PT parties. Matter is adjourned to.
Lord, if on the next date, my lord, same thing
After,
happens, then my lord,
kindly keeps it after 4 weeks, your lordship.
5th of October. October.
Full suits. Item number 22. Vishwanath Jhunjhunwala.
My lord, I appear for the defendant. My lord, kindly see the order dated 8th August. The main suit was there on that day. My lord, on that day, they gave us the death certificate of defendant number 1 who has died. In the main suit, he is the defendant number 1. And in the 2 applications that has appeared today, it's
order
their
sheet গুলো
application.
কোথায়?
I thought, my lord, here they have appeared.
None appeared for the plaintiff last date. Who is for the plaintiff?
22-23. Well, item number 22 and 23, in both the applications, I am the defendant.
20?
2 and 23. Vishwanath Jhunjhunwala.
None appears for the plaintiff. On 11 July 2023, also none appeared for the plaintiff. Let the matter be dismissed for default.
Grateful, your lordship.
23
Well, 22 and 23 are connected.
23টা দেখি order sheet দেখি। না এখানে 66 আছে শুধু, ওটা তো 67। Same order.
Sir, my lord, 66 and 67 both are their applications.
These are suit.
Main suit is coming on 21st September, my lord.
Who appeared for S. Banerjee?
Plaintiff, my lord.
Who appeared? S. Banerjee is representing whom? Last date appeared?
My lord, that is not known to me. Oh, my lord, he has come.
Chair, the order telephone.
22-23, my lord, I'm for the plaintiff, my lord.
Why are you not here?
I was in
Already
Lakes before
dismissed the
court
order.
number 41, my lord. I was in Lakes. But the plaintiff number 1 has died, my lord. A substitution application has been taken out, my lord. There are some difficulties. We have to clear it out before the master, my lord. Before the learned master, my lord.
Learned counsel appearing for the plaintiff. Praise leave to file necessary application. Praise for adjournment, as he is about to file necessary application.
Let these 2 applications be also taken together with the
Applications are
main
not
suit,
yet
my
filed.
lord.
What GA3?
GA3 is ours.
GA3 for is for?
My lord, I am not briefed in this
All right.
matter.
Let both the suits appear in the list along with applications on 27 September.
Deeply.
Grateful, your lordship. 27th.
24. Oh, no, no, 24.
Yes.
My lord, 24 and 25, my lord, I am appearing for the plaintiff. The problem is this, my lord, brief is not traceable, my lord. It's of lordship.
On prayer of the learned counsel for the plaintiff, matter is adjourned to 29 September.
No, my lord, I'm praying for the direction of lordship, kindly the department to provide, my lord, certified copy of the plaint and all
Have to apply, make an application.
Yes, my lord. And unless, my lord, the my lord, file with a record.
You have to
go
file the application.
Yes, my lord.
File the application, then mention it, I will pass order.
Grateful, my lord.
Your lordship, if I may mention item number 19, your lordship, which is fixed for arguments, your lordship. Even my learned friend is here. Your lordship, finally the court records have been found out, your lordship, because it was long pending for reconstruction, and pursuant to your lordship's last order, it has been found out. Now, your lordship kindly keeps it after a fortnight at least. We will commence our arguments.
তাহলে এটা লিখে রাখো, on the prayer of, you are for the defendant?
Yes, your lordship.
On the prayer of counsel of both the parties, argument is adjourned to 27 September.
Much obliged.
না না এইটা তো 19, item number 19. Item number 19 বিকেলে হবে, এটা লিখে রাখো, বিকেলে এটা অর্ডারটা করে দেবে, বা এখনো করে রাখতে পারো। 19টা adjourned হয়ে গেল।
My lord, this is not an application for certified copy or formal application, my lord, to get the certified copy, my lord. That is, my lord,
রেকর্ডটা পাঠিয়ে দাও রেকর্ডটা পাঠিয়ে দাও সার্টিফাইড কপি লেট হিম অ্যাপ্লাই ফর সার্টিফাইড কপি হ্যাঁ
না অ্যাপ্লাই করে দিচ্ছি আজকে। হুম, হুম, হুম। বলো,
Item number 17.
Yes. My lord will kindly take the plain ones.
Yes.
My lord will take page 7, page 11, where my lord the prayers are set up. My lord, the plaintiff's claim is for declaration of title. That is prayer A. B is a declaration that no wasting has happened. And C is a declaration of possession, is a decree for possession. And then, my lord, the
In profit.
consequential release. Now, my lord had framed certain issues. From what has been argued, it appears that, my lord, I am to answer.
Who is your other side?
I think.
I am for the defendant number 3, your lord.
Plaintiff?
State is not.
Plaintiff,
I am the
Mr. Ganguly.
State does not.
State. Also, state is also. All parties are here. State is with you.
Difficult to understand where the state is. Which side? Always, my lord, not just this matter anywhere. My lord, what has been argued is that the defendant number 3 is a Thika tenant since 1956 and continued to do so. Therefore, the land has vested in the state of West Bengal. Second, what has been argued is, this has been argued by the state, not by the defendant number 3, is that in view of provisions of section 5(3) and section 21 of the 2001 Act, this court lacks jurisdiction to proceed with the suit. Third is the cause of action for declaration of the suit is barred by limitation. Fourth is that the cause of action is even otherwise barred under Order 9, Rule 8 of the Code of Civil Procedure. Then Mr. Ghosh had touched on 2 points, briefly though, is that the suit is not properly valued. Therefore, it touches the pecuniary jurisdiction of this court also. And there has been misjoinder of parties. These are the more or less 6 various issues which have been argued on. These, of course, touches with all the issues which my lord had framed. Now, my lord, may I start with the issue of Thika tenancy first? Because everything will be connected to that issue. If they are Thika tenant, then, my lord, I am as it is out of this non-suited. If they are not, then the other issues will come. Now, my lord, before that, if my lord will kindly take page 381 of the volume 1 of Judges Before Document. Well, this is the deed of conveyance, which is, it will be evident from page 382, executed and registered on 18th July 1981. I purchased the property under this deed from Dhirendranath Seth, who was the son of Khetramani Dashi, the erstwhile owner. And the purchasers are, my lord, Srimati Chandra Devi Bothra, the original plaintiff number 1, Srimati Purnima Bothra, the plaintiff number 2, and Srimati Indu Bothra, the plaintiff number 3. Chandra Devi Bothra having died, plaintiff numbers 1A to 1D have been.
In terms of this agreement, in terms of this indenture,
I purchased the property.
Chandra Devi Bothra purchased the property.
Yes, ma'am. The plaintiffs purchased the property.
Yes.
In their written statement, at paragraph 12(1), 12A, written statement of the defendant number 3, my lord need not go through it, I'll read out.
just one, why I say this, because before I proceed, I need to establish my right to some extent. Now, the only objection here in the written statement at paragraph 12A was that the purchase was on 18 July 1981, which is after the 1981 Act has come into force. Now, my lord, this is factually incorrect, because the Act came into force on 18th of January 1982. Therefore, on the day when the Act came into force, whether there exists Thika tenancy or not, whether the defendant number 3 was a Thika tenant or not, and the property or my right was liable to be vested, the rights of the plaintiff, at least up to 17th January 1982, was established. Now, this has not seriously been argued also, but I just wanted to make it very clear. And my lord, not much of cross-examination also has taken place, except I think question numbers 223 to 225 of Sagar Malhotra's. So at 223 to 225 and 91 to 94. So my lord, as on the date when the Thika Tenancy Act of 1981 comes into force, I was the plaintiffs were the owner. Now, there has been a shift in the stand by the defendants, defendant number 3 to be precise, from what they had argued earlier, or the stance they had taken in the 1978 suit. My lord will recall that there was an earlier suit by Khetramani Dashi. Now, there they said that this sale is void because of certain ordinances which were passed. Now, my lord, in course of the
Which sale is void?
Sale in my favor. But that is not carried out here. No such ordinances have been placed before, my lord. The state of West Bengal also does not cite or bring into evidence any such ordinance. So at least my right to file, institute the suit to that extent has not been challenged. Now, my lord, now may I come to the main issue, my lord, the issue of Thika tenancy. My lord, Thika tenancy as a concept started on, my lord, on 1949. The exact date was 20th February 1949. That was the date when Calcutta Thika Tenancy Act 1949 was brought into effect. Now, 28. The Act defines Thika tenancy as somebody who is liable to pay rent to another, but has received a structure, has erected or has received by purchase or gift a structure which is not a permanent structure or a pakka structure for any purpose, either residential or industrial or commercial. Now, in 1969, an amendment was made. Section 2, subsection 4A was introduced and section 10A was introduced. This allowed Thika tenants who were residential tenants to make pakka structure with prior permission of the commission. Now, that is not an issue here. The other exception was, thus, my lord, the first exception to creation of Thika tenancy was whether there is the tenancy or even the structure which the tenant has includes a pakka structure or a permanent structure or not. If it was a permanent structure, then, my lord, it was outside the ambit of Thika tenancy. The second was if the lease was for a period in excess of 12 years. Now, my lord, may I at the outset clarify that I am not resorting to this exception. Here, the two deeds which created a relationship between Khetramani Dashi and KG Patel, the defendant number 3, were of 10 years and 9 years. So, under no circumstances they were in excess of 12 years.
because my lord knows that there are judgments in the premises tenancy in the under the rent statutes that renewal does not make a composite period. That is a different aspect. Now, my lord, may I quickly take my lord through the provisions of the 1949 Act once. It's my lord's book of common law also.
Yes.
It will be at page 155, my lord, I think.
You are referring to page, the section?
Section 25, 24A, 24A, I'll come later on.
Of 1949 Act.
Of the 1949 Act. Thika tenant means a person, any person who holds, whether under a written lease or otherwise, land under another person and is. Is it at page 156 of that book? Because my book is 156.
Who holds whether under a written lease or otherwise.
Otherwise, and is or but for a special contract would be liable to pay rent at a monthly or any other periodical rate for that land to that another person, and has erected and or acquired by purchase or gift any structure on such land for a residential, manufacturing or business purpose, and includes successors in the interest of such person, but does not include who holds such land under another person in perpetuity, or who holds such land under another person under registered lease, in which the duration of the lease is expressly stated to be for a period not less than 20 to 12 years, who holds such a land under that another person and uses or occupies such as a khatal. So under 1949 Act, khatals were outside. Now here, my lord, it is nobody's case that the occupation of KG Patel was for residential purpose. They were running a timber business from there. Their predecessor also were running a timber business from there. The next, my lord, I would the main purpose of the act is at page at section 5, my lord. This enactment created a forum for ejectment of Thika tenants. Notwithstanding anything contained in any other law, for the time being in force, a landlord wishing to eject a Thika tenant on one or more of the grounds specified in section 3 shall apply in the prescribed manner to the controller. So, my lord, a forum was created. And now, my lord, will come to section 15 of that. Rent. Yes, my lord. Every Thika tenant who makes a payment on account of rent to his landlord shall be entitled to obtain forthwith from the landlord or his authorized agent a written receipt for the amount paid by him and signed by the landlord. A counterfoil of the receipt shall be prepared and written by the landlord. The receipt and the counterfoil shall be in such form and shall contain such particulars as may be prescribed. This, my lord, correlates to Rule 8 and Form number 2 of the 1949 Thika tenancy rules. Now, that, my lord, Rule 8, my lord, will find at page 172 of the
yes,
of
receipt
the book.
and counterfoil. Form number 2.
Form number 2. My lord, will kindly see the 5th, if my lord has got the form, the 5th entry.
Thika tenant's name.
The Thika tenant's name. My lord, I shall rely on this part. My proposition is where a statutory relationship is being created or relationship governed by a statute is created, and the statute provides for a particular format in which the relationship is to be
evidenced, because a rent receipt is an evidence of the relationship either of a landlord tenant or a lessor or lessee, or in this case a landlord and a ticketer. So that has to conform to the format strictly. And this also is an evidence of the parties being consensus ad idem, having an agreement of minds that the relationship that is being created is that of a ticketer tenancy. Why this becomes important? Because of the subsequent two legislations. Now, my lord, in this my lord will kindly note certain dates in this issue. My lord, 12th March 1946 is the lease which Khetramani Dashi executes in favor of Muhammad Rasul. Now, what Muhammad Rasul did is unknown. Next date that becomes important is 8th November 1951, when the defendant number 3 claims it entered the property. It entered the property how? Under an agreement with one Vijay Timber Works. Thereafter, my lord, in 1955, Khetramani Dashi files a suit against Muhammad Rasul, gets an order of eviction. In 1956, thereafter, and at this point of time, defendant number 3 was in the property. On 30th July 1956, a 10 years lease is executed and registered, whereby the defendant number 3's possession is regularized. I would, my lord, use the term regularized because up till now, and I shall, my lord, show from the exhibits, and it's an admitted situation that defendant number 3 lacked any legal right to be in the property. It was at best an unauthorized occupant, if not a trespasser. And my lord, then is the exhibit 19, which is the 1966 deed. Now, my lord, if I can, in this line, take my lord first to
1966 deed is a deed of renewal.
Is a deed of renewal. There is some importance there, my lord, some relevance there. I shall take my lord through that. Now, my lord will first take exhibit 56, which is at volume number 5 of my lord's judge's brief of document. My lord, this was the suit which was started by Khetramani Dashi against Muhammad Rasul.
Page,
my lord, 1 of the fifth volume, my lord. It starts with a plaint, my lord.
18. I just brief it for them.
No, আরেকটা হবে তাহলে। আরেকটা এরকম হবে। এটা তো অন্যটা, আরেকটা দেখুন। না, earning. দেখি এটা কিনা। I'm sorry, my lord. This is volume 4. I think my marking is wrong. I apologize.
Yes.
At all material point of time, my lord will take the next page 2, my lord, of the plaint. It talks about Muhammad Rasul being inducted. Then, my lord, the second line, without any right or power to assign or sublet the whole or any part of the said land. By notice dated 24th December 1954, the aforesaid tenancy has been duly determined and terminated by and on behalf of the plaintiff. The defendant has not yet delivered quiet and peaceful vacant possession of the land. My lord, stepping aside from this matter, my lord, I see this plaint and the next plaint, my lord. A lot of
That is to be seen.
Kismal, even when the judgments of those times.
Absolutely.
2-page, 3-page judgments decided the questions of law. Well, this suit was decreed, and the decree is is annexed, my lord. Is also exhibit, I think, exhibit 57, which is at page 5. So, my lord, so Muhammad Rasul in 1946 was inducted as a lessee, and he did not have any right to induct any other person. And Muhammad Rasul neither the defendant number 3 also does not claim that Muhammad Rasul inducted them. Defendant number 3 says one Vijay Timber inducted them. In any event, if the lessee did not have any right, no person who held either under the lessee, they were unauthorized, they had no right to be in the property at the first place. My lord, in this connection, my lord will kindly note the questions in cross-examination which were put to the witness for the defendant number 3, Mr. Babulal Patel. Question numbers 343 to 345. My lord, question 343 says, in your evidence, you have said that Premji Patel had got into 45 Chittaranjan Avenue through some document created by Muhammad Rasul. Are you aware whether Muhammad Rasul had right to assign or sublet so far as 45 Chittaranjan Avenue is concerned? I do not know. His answer is, I do not know. Then, my lord, he is shown exhibit 56. Kindly read out paragraph 1. The witness reads, in page 3, in question 345, it says, can you therefore deny that Muhammad Rasul did not have any right to induct any person on that property? His answer is, from whatever is written here, I cannot deny.
So your contention is Muhammad Rasul had no right to induct any person.
Any person. And my lord, it will be preposterous to suggest, to even argue, particularly having regard to the fact that whatever is created on that day in 1949 ultimately leads to denial of my title in 1980, from 1981 onwards, that a person who enters unauthorizedly can create any.
But ultimately, Khetramani Dashi executed.
I will come to that, my lord. Can create anything or undertake any transaction which will create a legal right.
Even if he is a trespasser, then subsequently Khetramani Dashi accepted him and executed the
regular. I would, as I said, my lord, regularize.
Right.
This is one part of my submission, my lord. I shall rely on, my lord, I will show the judgments later on. But my lord will kindly note on this proposition that a trespasser. Now, may I take my lord through the 1951 deed first, then I shall rely on that. My lord will now take the first volume of the judge's brief of document. Exhibit 6.
Page.
This is at page, my lord, 39. Page 40. No, it starts with 39. That's the money receipt and
Indenture.
this Mr. Ghosh had placed. My lord, may I place it? Because I
MG
think.
Khimji.
Huh.
And
In the-
Vijay Timber.
Yes, my lord. Premji Khimji and Messrs. KG Patel. Now, my lord, before I take my lord through this, my lord, I tried to find out the date of entry or the manner of entry of Premji Khimji in the property. It is not mentioned anywhere. Next, my lord. Whereas the first party is desirous of closing down his business on account of losses incurred by him in the said business. My lord, this assumes that Premji Khimji, or rather Messrs. Vijay Timber Works, was in possession at any point between 1946 and 1951, 8th of November. And whereas the first party agreed to sell and the second party agreed to buy the stock in trade, fixtures and furnitures, one tin shed on the north and one tin shed on the south, belonging to the first party and lying upon the place of business. There is also no evidence as to when these structures were built. Now, if he came into possession anytime after March 1946, he could have built it even prior to the 1949 Act coming into force. Party at next page, my lord, 45 Chittaranjan Avenue, Calcutta. And whereas
What you
second
want
party
to say is that your submission is that these structures might have been built prior to 1949.
I bow down, my lord. There is no evidence has come forward that although Premji Khimji could have entered right after 12th March 1946, because I recall, my lord, either I don't think Mr. Ghosh, but Mrs. Banerjee or Mrs. De Banerjee, she probably submitted that Muhammad Rasul had left for Bangladesh. Had to be in partition. Now, if Muhammad Rasul had inducted Vijay.
What you want to establish or point to establish is that this is not covered by 1949 Act because this very tenancy, Onsetika tenancy, this tenancy was created prior to coming into
these structures were at least there, could have been there prior to 1947, prior to 1949, 28th of February 1949. Now, my lord, the second recital, and whereas the party gave stamped receipt acknowledging receipt of the amount to the second party, and whereas the first party has also agreed to let out to the second party. My lord, this was not highlighted, my lord. Perhaps. First party, that is Premji Khimji, agrees to let out to the second party, and the second party has also agreed to take on rent must be from the first party, premises number 45 Chittaranjan Avenue with a vacant land, and my lord will kindly note a shop room. In course of the evidence and in course of the argument, this was never highlighted that entry of KG Patel in the suit premises was primarily as a subtenant of Vijay Timber or Premji Khimji, another unauthorized person. And
repeated
entry of KG Patel was as a subtenant in respect of land and shop room, not under the owner, but under an unauthorized occupant who entered after the owner had given the property to a third party on lease. So, my lord, it's like Khetramani Dashi gives to Muhammad Rasul without any right to part with possession or create.
Muhammad Rasul to Premji.
Muhammad Rasul gives it to Premji Khimji.
And then Premji
Khimji creates another subtenancy in favor of KG Patel and sells the business to it. So there existed a shop room. This shop room is different than the tin shed on the north and the tin shed on the south. So some other structure, even this deed of 1951 recognizes that some other structure other than the tin sheds were in existence. The character of the shop room, nowhere it has been said that KG Patel has demolished the shop room. Even though, if this shop room was a pakka structure, this by itself would take it out of the ambit of 1949 Act. Even if it is assumed that the lease of 1956 created a Thika tenancy, could create a Thika tenancy. Then, my lord, the Habendum part, now this indentured witnesses as follows, that the first party has already sublet and delivered possession of the aforesaid premises number 45 Chittaranjan Avenue with vacant land and shop room standing thereon to the second party at a rental of 325 per month. So two trespassers, or to say the least, an unauthorized occupant.
One is Kimji and there is KG Patel.
KG Patel creates a transaction, partly subtenancy, partly sale. Now,
where you find sale?
Sale, my lord, clause 3, and read with the second recital, my lord, at page 40, has agreed to sell the and the second party agreed to buy the stock in trade fixtures, furnitures, one tin shed on the north and one tin shed on the south. So, my lord, there were three structures. There was a shop room, and there were two tin sheds, which had this stock in trade and furnitures and fixtures. So this is a transaction, my lord, between two unauthorized occupants, to say the least, my lord, even if I do not use the harshest, the harder word of being a trespasser. They create a transaction among them. And now this is being cited as the transaction which would bring the structure into the definition of Thika tenancy in 1949 Act, who either has erected or has received by
Mr. Ganguly, whatever there may be.
I understand what is troubling, my lord. I just want to say, my proposition is, until the possession was regularized with the 1955 decree, everything got obliterated. Until the possession was regularized, KG Patel had no right to be in the property. KG Patel could not have claimed a right of ownership on the structures in the property. And it is on evidence that after the 1956 deed, whatever was erected or repaired was a pakka structure, and therefore the 1956 deed could not have created a Thika tenancy at the first place. And the evidence of the relationship being created does not reflect the statutory format of receipt. My lord, if now my lord will come to on this issue, my lord, that
why are you operating this mobile here? Courtroom is not for operating mobile. Go outside. You go outside.
And my lord will see the recital also. The recital at page 42 speaks of a shop room. schedule, my lord.
45 Chittaranjan Avenue.
With vacant land and a shop room standing thereon.
Yes.
So subject matter of this deed was also not simplicity or vacant land. It was vacant land with a shop room. The nature and character of the shop room has not been brought forward before my lord. Although there are other evidence which will show that this might be a pakka structure. Now, my lord, I'll show two more documents today, my lord, then I'll come back on the next day. My lord, will take exhibit B18, which is all at pages 111 to 116 of this document, of the volume 1.
Hundred in
111.
11 received in full.
It starts at 110.
These are receipts.
These are receipts, my lord. My lord, I had shown, my lord, the form number 2. These are receipts which Nagendranath Seth's estate gave to the to KG Patel after the 1956 deed. I'll take, my lord, through the 1956 deed, but kindly see. And my lord will now compare this with the receipt, the format of the receipt at page of the 1949 rules, form number 2.
Yes. Not telling with.
This does not satisfy the statutory format. Now, if a statutory relationship is being created and a format is provided for which receipts are to be granted, they must conform to each other. My lord, why I show these to my lord is that even in 1956, the parties did not contemplate that this was a thika tenancy. This is a proof of the fact that actually, my lord, until 1981, the question of treating this relationship as a thika tenancy did not come. The issue of thika tenancy came when the state started considering in maybe late 1980s or early 1981 that we shall take over these lands.
So your point is that there is no thika tenancy under 1949 Act.
At all. First, there was a shop room. Entry of KG Patel is not just by purchasing the structure. The purchase of structure was a point of time when both Vijay Timber and KG Patel were trespassers or to say the least, my lord, unauthorized occupants. Then they take the 1956 lease, and this is the receipt. This receipt does not tally with form 2. So parties were not even contemplating anything at that point of time. Now, my lord, will now take just one more document I shall show, and then, my lord, two statutory provisions, and then I'll come back and page, my lord, 135 of this. This is exhibit 23 and 24, my lord. My lord,
Corporation of Kolkata.
Yes, my lord. My lord will recall that Mr. Ghosh had said that he had taken sanction to make certain structures. Now, kindly see what is the structure which is being allowed. My lord comes to the place where 2 Jethalal Khimji. Thereafter, my lord, the type portion.
Grants permission.
Corporation hereby grants permission to execute the work as per plan or application of 2. My lord, there are 2 things. One is erect anew, and then there's a underline, and then at the bottom below it, alter or add 2. Has my lord found that? After the handwritten portion at the middle of the page, my lord. May I, my lord, show? My lord, here. Jethalal Khimji, 45 Chittaranjan Avenue. Then third, the corporation hereby grants permission to
Alter and add to
alter and add to what?
masonry building.
Masonry building. My lord,
That means you say there was a masonry building.
yes. This is a proof of the fact that at least one solitary masonry building was present. My lord will take, my lord, may I my lord, masonry building is defined at section 2 subsection 51 of the Kolkata Municipal Corporation Act 1980. I assume it had the same definition then also. My lord, 251. 51 এর definition. So 51 এ কি ছিল দেখো একই জিনিস ছিল। I shall try to find out a 1951 book, my lord. Since Mr. Dashgupta is saying that 51, it says any building other than a hut and includes any structure substantial part of which is made of masonry, reinforced concrete, steel, iron or other metal. And now my lord will take now section 2 subsection 4A of the 1949 Act.
Two subsection
4A. That is the rules.
Pakka structure,
Yes, my lord.
brick, stone, concrete, or combination.
Any structure
Page
constructed
156.
mainly of brick, stone or concrete or any combination of these materials, more or less identical. So in 1957, this is I think of 1958, 8 January 1950, application is made on 15th October 1957, approved on 8 January 1958. The application was to alter or for addition or alteration of a masonry building, which, my lord, in my respectful submission is a pakka structure, because the two definitions are more or less same. Until 1969, when section 10A was introduced, no thika tenant would have erected a pakka structure. From 1949, only from 1969, only a thika tenant who had taken on the tenancy for residential purpose could have raised with the permission of the controller, not on his own. Because, my lord, the logic says that landlord and tenant had to understand what relationship they had entered in. And the statute provided that you go before the controller, take his permission before you even go before the Kolkata Municipal Corporation, Calcutta Municipal Corporation, then to take permission to raise a masonry building or a permanent structure or a pakka structure. Now here, my lord, at least 12 years before the said amendment comes into force, KG Patel goes to the Kolkata Municipal Corporation, no reference to the controller, could not have. KG Patel holds the property for business purpose, for commercial purpose. It's not a residential tenant. And seeks the permission to add to or alter an existing masonry building. It's not a new masonry building because that part is cut off. So there was an existing masonry building. So if there was a pakka structure and KG Patel took lease of such pakka structure, then under no circumstances the relationship between Khetramani Dashi and KG Patel could have been that of Thika tenancy. My lord, I don't know whether the plan is annexed there because in my possession there it's in a separate exhibit. কত ছিল রে প্ল্যানটারে? Exhibit 24 or 25? 24.
So suppose this is not a Thika tenant or there is no Thika tenancy, what bearing it has on the main issue?
If this is not a Thika tenancy, my lord, then the jurisdiction is irrelevant. Then the only issue that will be that what is
Subsequently,
it cannot be vested.
no, subsequently Khetromani Dashi made an agreement or lease, whatever that might be, with this person.
This is after the agreement. My lord, I haven't shown my lord the 1956 deed. This application is dated 1957. The receipts I had shown, my lord, the exhibit 18. That is from 56. That is what Khetromani Dashi gave. So the receipt which Khetromani Dashi gives after 1956 does not reflect Thika tenancy. The permission for construction which is obtained is addition and alteration of a masonry building, hence a pakka structure. So if there is a
No,
pakka
the question that Mr. Ghosh raised is that till you purchase the property, there was outright purchase. But after coming into force of 1981 Act, your view, your right are no longer in existence.
My lord, under 1981, only a property which is held in Thika tenancy from under 1949 Act can only vest. Well, there are series of judgments starting with Jatadhari Da, Lokshimani Dashi, and lastly, my lord, Money Square.
That is your connection.
Yes, my lord. If it could have was a Thika tenancy, as I started off by saying, if it was a Thika tenancy, I would be non-suited. There is no two ways about it.
Right. All Thika tenants shall be vested in the state 1981 Act state. So your point is there was no Thika
There
tenancy.
is no Thika tenancy. The structure is purchased at a point of time when the purchaser and the seller are trespassers. Trespassers cannot claim any right. After it is regularized, the next, my lord, when were these? So there are two temporary structures, the two tin sheds. There was
If you come next day, I will hear it.
I will again, my lord, place those parts again.
All right. Heard in part, heard the learned counsel, Mr. Ganguly. In part, who have submitted on behalf of the plaintiff. When you will be able to make next submission?
As my lord says.
Sixth,
my lord, there is an appeal. There is an appeal.
6 তারিখ পরে দিন।
My lord, before 6th, any day.
5th করো না।
My lord, 11th.
11th.
Item number 18, Dolok Singh Surana.
Yes, you are continuing your argument.
My lord will recollect, the plaintiff had filed a suit primarily claiming that from 1986, the government had been illegally occupying this property, Pretoria Street, and claiming compensation and damages on account thereof. My lord will once take up the particulars of claim.
Microphone is switched off, I think.
Page 14 of the plaint. Sir, page 14 of the plaint.
Yes.
Paragraph 22. The most important date, no doubt, is the date of vesting. But other than that, there is another aspect of the matter, my lord. Particulars says for the period from June 1, 1986 to July 31, 2004. My lord, one thing happened after the filing of the suit, which we have stated in the written statement also. which is the land acquisition collector awarded compensation. Because as my lord will recollect, the land was ultimately taken over under the Land Acquisition Act, proceedings under section 4, section 6. The award was passed, objections were received, everything was decided. So this award or compensation was calculated with effect from the year 1995. So compensation has been accepted with effect from the year 1995. The award is also a part of the, my lord, I have two judges brief, my lord. At 267, this is possibly the defendant's judges brief. Page 267, we can find the award of the collector from 1995. Compensation has been accepted, my lord. So any claim after the year 1995, my lord, in my humble submission cannot be sustained, my lord.
No, the claim is made from 1st June 1986
to July
31, 2004. That is one part.
Then
1st August 2004 till June 30, 2007. So your point is that after 95, claim cannot be made.
Cannot be made, my
But
lord.
there is a claim from the period of June 1, 86.
Absolutely.
If
But
I
I'll come
accept
with
you,
that.
till 95.
This is the point I am trying to deal on the basis that land vested in 1986. I had placed judgments of the Honorable Division Bench of this court showing that although there was a de-requisition, there was a requisition, and subsequently, my lord, the land was acquired. There are judgments saying that this whole process continued. The land stood vested. I'll be placing another on division.
No, one thing is not clear to me.
My lord.
Land was vested with effect from
1986 in our humble
August
submission. August
1986. 14th August 1986. You paid compensation with effect from August 95. So what about this intermediate 10 years?
My lord, compensation was paid as calculated on July 1995, my lord. My lord, 10 years compensation was paid to them. Because my lord will
10 years
recollect,
compensation was paid to them. When?
my lord, intermediate payments were made. My lord will recollect, there were orders from the Honorable Supreme Court of India. Intermediate payments were made. In fact, my lord, we have made a counter claim where we have said this was the awarded amount. These are amounts were paid in excess. I have a counter claim also. Intermediate payments were made to them, my lord. Pursuant to Honorable Supreme Court's order, my lord, there was a valuation done. On the basis of that valuation, intermediate payments were made. Ultimately, the SLP was dismissed. The order was placed before.
Where is that order of Supreme Court?
My lord, the Honorable Supreme Court's order, my lord, it is annexed to the plaint itself.
Paper book?
Starts at.
It's in plaint.
Annexed to the plaint itself, my lord. It starts at page 34, annexure D. This is.
Yes, Supreme Court allowed certain compensations or certain payments. For which period?
My lord, this land acquisition proceedings were challenged before this honorable court,
Right.
before the honorable
But
division bench.
intermediate compensations was awarded by Supreme Court from time to time. Was it from this specific period? What was the order?
My lord, what was said was pending the appeal, these are the intermediate payments you ought to make these payments. This is the final order, my lord, which I just pointed out. Kindly gives me a minute, my lord. But there is an order, my lord, of 13th August 2004, which is annexure A at page 28, whereby the Honorable Supreme Court directed the High Court to appoint a valuer to fix up the rental value damages since June 1, 1986 to the end of July 2004.
Yes.
My lord, pursuant thereto, on 11th April 2005, my lord, the Honorable Supreme Court directed the valuation report to be examined by another valuer. My lord, July 1, 2006, July 11, 2006 at page 31, my lord, kindly sees. There were two reports, both the reports were placed, my lord, and ad hoc payments were to be made. And in fact, my lord, it was ordered in case in any other proceedings determination is further, amount already
So
paid would
payment
be
is
adjusted.
for the period
June
Stretching
1,
from June, 1st June.
1st June 1986 to the end of July 2004. Because all along, my lord, the proceedings were being challenged. The land acquisition proceedings were being challenged by the plaintiffs. Section 4, Section 6, everything was challenged. Ultimately, my lord, the challenges were rejected, my lord, also by the Honorable Supreme Court. In the interest of justice, we directed the respondent to deposit an amount of rupees 25 lakhs to the appellant petitioners within 8 weeks, shall continue to pay rental at rupees 3 lakhs.
So compensation was 32 lakhs.
25 lakhs initial amounts, 3 lakhs from 1st July 2006 till final disposal of the appeal. At page 33, my lord, will find.
Damages assessed for the period 1st April 86 and end of 2004.
My lord.
That is 31st July 2004.
31st July
Are
2004.
to the tune of, this is 3 lakh or 32 lakh? What is the amount? Five or 3?
My
Five.
lord is at page, my lord, if I may humbly ask, my lord is at page.
Page 30.
Kindly gives me.
Little bit smudged.
My lord. This is 3 lakhs, 30 lakhs, 30 lakhs, 11,701.
No, not this one. Go to the second line. 31st July 2004 are to the tune of, then
This is 5,527.
It is 5 or 3?
This is 5, my lord. My lord will find the same figure at page 32, which is clearer and legible.
5 crore 32 lakhs 70,000.
52 lakhs, my lord. 5 crore 52 lakhs 70,000.
Okay.
This was the assessed damages. My lord, another valuation report was brought in. Both the reports were compared on the next date. And the order at page 31 was made. When all these amounts were paid subject to the ultimate result of the SLP. My lord, sees last line of 32. In the interest of justice, we direct that the respondent to deposit an amount of rupees 25 lakhs to the appellant petitioners within 8 weeks and shall continue to pay the rental at rupees 3 lakhs from 1st July 2006 till disposal of the appeal. We make it clear that this determination of the quantum of damages for which notification is sought is subject to determination by any other authority. The parties would be at liberty to have recourse to other remedies. In case in any other proceeding the determination is furthered, the amount already paid by the respondents would be adjusted towards damages for use and occupation. We also make it clear that the parties on either side will not press for the question of limitation in case of any litigation resorted to by the petitioners in this case. Ultimately, the SLP was allowed, my lord.
Yes. So you made some payments.
Some payments were made at that time, my lord.
Then?
Well, thereafter, the SLP was allowed in my favor, my lord. Award was made. Entire awarded amount was accepted, my lord. The assessment was made with effect from 1995. Market value as at 1995 was taken by the land acquisition collector. So from 1995 onwards, my lord, there cannot be, in my humble submission, any claim for damages and compensation because compensation under the Land Acquisition Act has been accepted. So the particulars of claim, my lord.
Why the claim is made in respect from the 1995 onwards?
My lord, when the suit was filed, this award, the passing of the award by the Land Acquisition Collector and acceptance of payment was all subsequent to the filing of the suit. Suit was prior to the passing of the award. The suit does not.
July 2000.
July 2007, the suit was filed in July 2007. The award, my lord, was passed thereafter, my lord, in 2007 itself.
Award was passed on 15th November 2007.
15th November 2007
267.
of the defendant's judge's brief. I was placing the award, my lord, at page 267 of
Award by LA collector.
LA collector, my lord. They had accepted payments. In fact, that is also recorded, my lord, that checks were accepted. The award records that. The various plaintiffs' checks
So
have
you
been paid.
please that once the award is accepted, they cannot claim damages.
After the period on which the award proceeds to assess the market value, at least thereafter. My lord, my contention is twofold. The land vested in August 1986. So since the land had already vested, there cannot be any question of claiming damages and rentals. My lord, the second limb is from 1995 compensation was assessed. They had accepted that in 2007. The acceptance is also recorded in the award. So, my lord, at least from 1995 onwards, they cannot have any claim for damages and rentals.
What about claim from 1986 to 1995?
That would be covered in my humble submission by my contention that the land had already vested in August 1986. Because my lord will recollect, this premises was initially acquired under the Defense of India Act. Acquisition proceedings, there were...
All right. There is a claim. We forget about all the past things. He has made a claim from August or from June 1986.
June 1986.
So you have paid compensation from 1995 onwards.
Compensation taking the market value at 1995.
Whatever that might be, a compensation is paid from 1995 onward. Then what about the previous part? Unpaid part, that is from 1986 to 1995 part.
My lord has already seen that pursuant to the Honorable Supreme Court's order, I have made payment of various amounts as assessed by the...
That will cover this period.
So it is recorded in the order that it is from 1st June 1986 to 2004.
So you have paid ultimately to him in terms of order?
In terms of the Honorable Supreme Court's order, my lord, which I just placed, we have overpaid. We have a counterclaim. My lord, page 31 was the order pursuant to which we started making ad hoc payments.
5 crore 52. This you have paid.
Well, I have not paid 5 crore 52. This was what was assessed. My lord sees the order at page 31. The order of
you
the
have paid
Honorable,
pursuant to the order of the Supreme Court.
this order at page 31, which is dated.
Yes, here it is
10th
mentioned 552.
This is the compensation which was calculated by the valuer. Ultimately, what the Honorable Supreme Court directed, my lord, takes up the last line at page 32. In the interest of justice, we direct that the respondent to deposit an amount of rupees 25 lakhs to the appellant petitioners within 8 weeks and shall continue to pay the rental at rupees 3 lakhs from 1st July.
This is the payment you made.
This is the payments we have made. My lord, in my written statement, I've summarized what I have paid and I have made a counterclaim because I have made overpayment, my lord.
Written statement কোথায়? Yes. Where have you stated
Page
this?
20.
Plaintiff received 52 lakhs 92,000. 521.53 paisa, as you stated in your written statement.
Now this is 1 crore 28 lakhs 20,000 at page 23. Apart from this, I have paid 95,000, which I have said in paragraph 26.
Paragraph 26.
Paragraph 23 is the chart, my lord, the chart showing payments.
Paragraph 23.
And apart from that, there is
Paragraph
another,
23 of
my written statement.
এইটা written statement on behalf of plaintiff, written statement on behalf of defendant দাও।
Would it be convenient for your lordship if you prepare a chart as to when and how payments have been made?
Issue is not the chart itself. Issue is the head. (23)
Paragraph 23 at page 20.
Yes, 1,28 lakhs 20,000. This you have paid.
This we have paid.
Under heading? Under order of the Supreme Court.
Pursuant to Supreme Court's order.
Pursuant to Supreme Court order, this you have paid.
In addition thereto, another sum of rupees 95,000 was paid, which is stated at paragraph 26 on the next page.
95,000 you have paid.
95,000.
Now, all these payments were made on the basis of calculation or order of the Supreme Court.
Ad hoc calculation.
Whatever that might be. Under order of Supreme Court, you have paid this. How this court can say this will be refunded when the order of Supreme Court is there?
The order was subject to the final result of the SLP.
At the
SLP
final
was
result,
ultimately
Supreme Court
dismissed.
never said it will be refunded.
Well, it was said that Malad kindly sees the final order of the Honorable Supreme Court once.
Yes.
The final order starts at page 34. This is an order dated
34,
November
it ends
13.
at page.
34, it starts November 13, 2006.
Yes, it ends at page 79.
80, my lord.
All right, 80. Where there is order.
My lord, page 79, the last paragraph.
Who is the appellant in this case?
My lord, the plaintiffs before your lordship are the appellants in this case. My lord, section 4, section 6 was challenged. The Honorable Trial Judge had set aside. The Honorable Division Bench has upheld the acquisition proceedings. The plaintiffs went up in SLP. The SLP was dismissed. So the acquisition proceedings were upheld. My lord, the acquisition dates back to.
Now, one thing is clear. First part, you have claimed refund. That is your counterclaim.
That is my counter.
There is no scope. Supreme Court ordered refund payment of certain amount of money. Towards compensation, rent, whatever that might be. One party is ad hoc payment, another party is continuous payment of rent at a rate of 3 lakhs. At the end of the litigation, that was all these payments were subject to outcome of the SLP. At the end of the SLP, there is no order that in case it is found overpayment is made or anything like that, it is to be refunded. That is not there. So when Supreme Court has passed one thing, I cannot say let it be refunded. That point is issue is there.
My lord, we will try to satisfy your lordship that when payments were made subject to the final outcome of the proceedings, I can claim refund. We will try to satisfy your lordship. We will satisfy your lordship.
Come on the next date.
Kindly allow me to.
But this is first point. Second point is if you have paid with effect from 95 onwards, what about the payment in respect of the previous 10 years?
My lord, if I may say so, as on 95, the market value was computed. But I'll come back on that. Kindly, I understand what is going through your lordship's mind.
Whatever you may calculate, whatever is available, that's a separate issue. Your acquisition is with effect from 1986. So I am legally bound to pay compensation, even 1 rupees to them. So what about that, your argument on this issue?
These are the two queries which is troubling your lordship.
Heard. Mr. Dr. the Learned Counsel for the state in part. Adjourn to when will you come?
Anytime third week of September, anytime.
Third week will be too late. It's a long pending case. 12.
No, Milord. A lot of things are fixed. Milord. Give it next week, Monday, Tuesday, whenever.
third week আরেকবার request করো 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 স্যার
Too long, Milord, too long.
Is that this the next, just the Monday, Tuesday, anyway, just the next week. Milord.
Next week means 5, 6.
No, Milord.
Yes, yes.
18.
Yes, 17, 18, 19, 18.
But finish with that week. Answer me and try to finish your argument within that week. 18 September. Because your point is very short and very pointed, in fact.
Get it.
Witness action, item number 20, Rajkumar Agarwal.
In this matter, I am for the defendant, my lord. This for the DW1.
Plaintiff, my lord. My witness action has been completed. Let they have to not bring his witness.
My lord, today he is suffering from viral fever, my lord. Just 4 or 5 days, I shall have he will be available.
Prayer of the learned counsel for defendant.
Defendant.
Witness action is adjourned to
6th or 7th, my lord.
7th is a holiday.
6th, my lord.
6th September.
6th September.
Oh, then 8th September. 8th.
8th they will not come. Definitely, I'm sure he will not come.
6th, my lord.
21.
দুটোর সময় তো 6th at 2 p.m. My lord,
At 2 p.m. Yes.
My lord, I am appearing on behalf of the defendant, my lord. In this matter, my advocate on record has been suffering from, my lord.
Where is the plaintiff?
The plaintiff is nowhere suffering from, my lord, post-operational bypass surgery.
No issue, but where is the plaintiff?
Plaintiff is not here, my lord.
None appears for the plaintiff.
Well, if your lordship keep the matter after vacation, because I have been newly briefed in the matter, and
No, let the plaintiff come. I will dismiss the matter if none appears.
yes, my lord, then
Learned counsel for the defendant is present. Adjourned to
my lord,
11 September.
my lord, because I renew my prayer, because my advocate on record is yes, my
If
lord.
the plaintiff doesn't appear, it will be dismissed.
Lordship,